For pronouncement of judgment, item 40 to 42.
We have held there is no need for interference with the order of the single judge because there is no ouster of jurisdiction of the Reed Court. We have given elaborate reasons, but we have asked the learned single judge to decide the matter expeditiously by keeping all questions open, including the point of locus of the petitioners to move the High Court.
Obliged.
For judgment, item 43 to 51.
All the writ appeals are dismissed.
Item number 1. Yes, your lord.
Yes.
Item number 1, your lordship. Yes, Jonathan.
As per the order dated 5/2/2024, the controversy involved in this PIL petition is also pending consideration before the Honorable Supreme Court. Hence, the matter is adjourned, awaiting the verdict of the Honorable Supreme Court on the similar point.
Obliged, your lordship.
May I please, Lordship? With the consent of other side, I beg to mention item number 4, Lordship. Lordship, this may be kindly adjourned for today.
Adjourn.
Obliged, Lordship. May I please, your Lordship? So I beg to mention item number 11 of the daily list. my lord.
Adjourn.
Obliged.
Lordship. I'd like to mention item 22, your lordship, with the consent of other side, your lordship, for 3 weeks at least, your lordship.
Adjourn.
Obliged.
I beg to mention item number 28, Lordship.
Adjourn. Adjourn.
I beg to mention item number 27.
Yes.
Lordship, this is not by Lordship. Lordship, justice, Lordship.
Under the
Order.
bench.
Yes.
Collected, and this is Shriman Shyamji collected.
I beg to mention item number 26, Lordship.
Yeah.
Similar matter has been fixed on 6th of June, Lordship. So the item may be tagged with the retable, Lordship. That's 157
Who
of
is for the other side?
the government one.
Who is for the other side? Have you informed the other side?
No, Lordship. Similar matter is fixed. Lordship.
When counsel for the appellant has submitted that identical writ appeal. Number so and so, number so and so
Yes.
is fixed for 6th of June.
Yes.
List on 6th of June along with so and so.
Deeply. Lord.
Wait, please, your lordship. May I be permitted to have a matter listed, my lord? Sometime in 8th, 9th, 9th or 10th.
What's the urgency?
I'm 82 and ailing.
82 and ailing. What is the controversy?
Controversy is that the lower amount of pension is being granted to me by a decision by the honorable single judge. We put that in appeal.
And the matter is pending since
No, we have filed it. It's a fresh appeal.
the fresh appeal.
Fresh appeal.
Next week, may whatever.
Lordship, obliged lordship.
May I please, Lordship? Also, I beg to mention item number 31, Lordship.
Yeah.
31. Lordship, we supposed to file an additional affidavit, but the leading youngest counsel is bedridden situation, Lordship.
Who's for the other side? Who's for
Government,
the other side?
no, Lordship. Item
For the other side, Your Lordship,
31.
he has not taken my consent. They've been adjourning the matter since several months.
Now she's is saying that the arguing counsel is bedridden.
Bedridden, Lordship. That's why we could not file the additional affidavit, Lordship.
Okay, then counsel for the appellant has submitted the arguing counsel is disposed of. Indisposed. Adjourn.
My lord, with the concern of the other side, I beg to mention item number 36 of the daily list.
Yeah,
My lord, I pray for a short adjournment in
adjourn.
oblige.
May I please, my lord? I beg to mention item number 33, my lord. In this case, senior counsel, Mr. Zero is conducting this case, my lord. So my lord may not like to take up the matter.
Not like to take up the. Another bench.
Highly obliged.
This is another bench without having Justice Suman Sharma as member. Yes.
Supplementary list, item 54.
Lord, with the lordship's kind permission, my lord. My learned friend is midway. I have informed my learned friend, in any case, he has a right of reply. So with the lordship's kind permission, can I place otherwise I'll be clashing with the other matter. I'll just take 15 minutes time. I have informed my learned friend, he agrees. Of course, now it is up to your lordships. Because in any case, he has a right of reply.
Just a minute, what is the formulation here? What is the formulation?
At least he may conclude his arguments, then whatever it may be, we have to,
In that case, lordship will kindly accommodate me for some time.
yeah.
Yes, yes.
You come back?
Met with the lordships. Well, at yesterday.
Mr. Mahanta, what is your submission here? What is the point you're trying to make?
My point is that the law, as I placed it yesterday, makes it abundantly clear that the tenure post holder will complete the tenure and he cannot be made to retire at the age of 60. This law is not applicable to him.
So your case is regardless of what is mentioned in the order of
Yeah.
appointment, which says 5 years or attaining the age of 60 years, that 60 year has to be ignored. It has to be 5 years.
Yes.
And that is because of the two provisions you have shown yesterday. That's your argument. Let him reply. What else is there to argue in this? We'll consider it.
Well, just that can happen. But before that, I will place just two provisions, which will give a picture again.
Yes.
That whether, well, because the question is now, if normally the normal employees, ordinary employees will retire at the age of 60. There are two groups of officers. One is the tenure post holder, the other is the normal officers who will retire at 60. Details, if required, I will take your lordships. The law makes it abundantly clear. Now, if a tenure post holder is appointed just before 60 or say after 60 immediately, how long he can continue in service? Is there any provision in law? So it says that maximum age is 65. 65 years, this lordship will find 121 page number. Just to make this clear.
63, it can be extended in
No.
special cases, the discussion.
63 again, Well, that is 60 can be extended up to 63 in case of ordinary employees,
Yes,
subject to 1 year at a time. Not
1 year.
beyond.
Subject to,
So not 3 years at a time. 1 year or beyond, not beyond 63 years again, 63. Kuntu? First Lordship will take it, Ordinance 7, page 120.
For the Board of Management interest of re-employment beyond not
Rule 4.
absolutely necessary for how does it cover it? This is what the power of the board is.
yes,
Well, at page 120,
120.
120, this is the Ordinance 7, which was passed under the state.
Yes,
Here, kindly see, uh, 2, Rule 2, tenure of appointments. The tenure of appointments on contract basis shall generally be 5 years, or as the case may be decided by the Board of Management by Chancellor. Here also it says generally 5 years. And in case of this tenure post holder, it specifically said Rule 3, 5 years. Now, kindly see, down below, Rule 3, Sub-Rule 2. All appointments on contract basis shall be for a specified duration as may be decided by the Board of Management in each case. Those in which case it is not fixed. The appointments will automatically terminate at the end of the duration. So there is no question of retirement. Automatically terminate on the completion of the duration, he will go. The administrator, however, decide on the basis of needs and service of performance further appointments for one or more terms of similar duration. So terms again, one can be. Then kindly see 4, Rule 4, that's a Rule 4. No person who has completed 65 years of age will be appointed on contract basis or continued as such. That is the highest age bar prescribed. After 65, no one can put it, even on contract basis. So this is applicable to me also. So my small submission is, if a person is appointed, did learn a single judge just taken a well at consideration that I was 57 that time. So authority allowed me to participate, relaxing the age. They said that it's 55.
yes.
Learned single judge thought. Perception is that 55 plus 560. That's why for 5 years you were given.
No, you were not,
That is, in my small submission, is not applicable here. That is a wrong appreciation. It's a wrong appreciation. Not applicable. So, Malad, here apparently, what you will see, the appointment itself, in the advertisement itself says it's a 5 years term. We want to recruit. Appointment letter included that 60 years. The question is whether that would have any bearing on. Lordship rightly put this question. Single just said that yes, it cannot be said to be illegal.
that is in consonance with the, whatever the provisions.
The
of the
provisions,
regulation.
reading Rule 9, conjointly reading Rule 9. That is, Learned Single just said that it can be constituted to be a valid clause put there. In my small submission, that Rule 9 even was wrongly construed by the Learned Single Judge. Because here the learned civil judge really go to the aspect that there are two groups of officers. One is the tenure post holder separately put. The other is the ordinary officers who is to retire the ordinary age. In their case, that re-employment. And in case of tenure post holder, is the reappointment. By following the same process as Lordship yesterday placed it. I was recruited again by following the due process of selection. I was put in probation. Again, the same things repeated. Therefore, it is not a continuity. It is not like any other ordinary ordinary employee. If he attains the 6 years, the department finds that services are needed, he can be re-employed simply issuing an order that he can continue for another 1 year or 6 months or whatever may be the term. So therefore, all these considerations and we cited the examples also that in that institution itself, the registrar who was appointed in the same way. Who appointed me? He himself continued beyond 60 years. And when his term completed, he only left the job. That was, we cited that example, should be placed on record.
Any
For
law,
spending that.
any law in support of your
Yes,
argument?
my lord, that condition, the condition which has come on the appointment letter, the 60 years, it is of no consequence because when the rule specifically makes it clear, contrary to the rules, any condition incorporated in the appointment letter cannot have any bearing. That is the law. The apex court has said that. I am placing that law. That is Arun Kumar. Hmm? Yes, Arun Kumar Roy, Union of India versus Arun Kumar Roy.
Yes.
1886, 1 SCC 675. Sorry, 1986. 1986, 1 SCC 675. Should I just take your lordship to the relevant paragraph?
Yes.
Will kindly come to page relevant, page 683. Paragraph 18.
Yes.
The question whether the terms embodied in the order of appointment should govern the service conditions of employees in government service or the rules governing them is not an open question now. It is now well settled that a government servant whose appointment though originates in a contract, acquires a status and thereafter is governed by his service rules and not by the terms of contract. The powers of the government under Article 309 to make rules to regulate the service conditions of its employees are very wide and unfettered. These powers can be exercised unilaterally without the consent of the employees concerned. It will therefore be idle to contend that in the case of employees under the government, the terms of the contract of appointment should prevail over the rules governing their service conditions. The origin of government service oftentimes is contextual. There is always an offer and acceptance, thus bringing it to being a completed contract between the government and its employees. Once appointed, a government servant acquires a status and thereafter his position is not one governed by the contract of employment. Public law governing service conditions steps into regulate the relationship between the employer and the employee. His emoluments and other service conditions are thereafter regulated by the appropriate statutory authority empowered to do so. Thus, regulation is permissible in law unilaterally without reciprocal consent. The court made this clear in two judgments rendered by two constitution bench such and such. Again, 19. Thus, it is clear and not open to doubt that the terms and conditions of the service of an employee under the government who enters service on a contract will, once he is appointed, be governed by the rules governing his service conditions. It will not be permissible thereafter for him to rely upon the terms of contract which are not in consonance with the rules governing the service. Here, my lord, just reverse had happened. Certain conditions was mentioned in favor of the employee. The employee wanted
Those, you mean to say that those conditions were not in consonance with the regulations?
Therefore, 60 years that was put in, that was not in consonance with the rules, therefore this is not. I'm grateful, man. Yes, sir. Now, this was also reiterated by our High Court in the division bench decision.
Yes. Yes.
So this was relied upon by our court, my lord. It was reported in 1999 3 GLT, page 90. Relying on that, this honorable court also said, decided this case. I am not taking your lordship to the details.
there is no need of.
Principle incorporate 1999 3 GLT 90. It is the case of Tabang Pasar, State of Arunachal Pradesh.
So if they have relied upon this, the
Yes.
Supreme Court judgment is enough.
Yeah. And my lord, regarding the question which may also come to the mind, that since it was there at the beginning, that 60 years mentioned in the appointment letter, whether I can challenge it, if not on the very first day, whether I can challenge it later on. That question may have agitated the minds. Apex Court said that this is immaterial. You can at any time come and challenge it because it is to your prejudice against the law. Which is exceptionally bad, it is bad always. And you do not have the bargaining power. Since you do not have the bargaining power, the authority has put in something, you are seeking for a job, you have to join it. You cannot bargain, it is for the authority. Therefore, this will, the learned single has accepted it, said that therefore this, of course, he has accepted it. There is no difficulty, I am just placing it. Reference, lordship may take note of. In paragraph 43 of that Arun Kumar's case. Somesh Taplial's case. Somesh Taplial case. The court has said like this, I will just read out.
The citation of that.
2021 10 SCC 116.
2021,
Yes.
2021, 10 SCC 116. Sumesh Tapliwal and another versus Vice Chancellor HNB Garwal University and another.
Yes,
Lordship may kindly turn to page 131, paragraph 37. I will place few paragraphs, but then I will consolidate, considering the time. I will cut short and refer to.
yes,
Two paragraphs I will place. First, Lordship may kindly take up paragraph 37, page 131. From, Lordship got it, my lord. Should I read it? From the narration of facts as being referred to supra, is clearly manifested that the appellants were appointed after going through the process of selection as contemplated under Part 4 of the 1973 Act, which indeed was an appointment on substantive basis, and since the appellants were not in an equal bargaining position and were in the need of employment when the offer of appointment was made, were left with no option but to accept such arbitrary conditions incorporated in the letter of appointment, in treating it to be contractual for a limited period, still recorded their protest while joining, but no heed was paid. When they were allowed to continue by extending their services, they remained under the bona fide belief that as their appointment is being substantive in character, they will be made permanent, confirmed immediately after the permanent posts are sanctioned in the Department of Pharmaceutical Sciences. But to their dismay, after an advertisement that such came to be notified by the respondent Central University, no option was left with them but to approach the High Court by filing the writ petition, because they were sought to be relieved and those posts were advertised. They were those substantively appointed but shown as contractual. Therefore, they came when advertisement was. So now, kindly come to 134. 134 page.
yes,
43, my lord. The bargaining power is vested with the employer itself, and the employee is left with no option but to accept the conditions dictated by the authority. If that being the reason, it is not open for the employee to challenge the conditions if it is not being in conformity with the statutory requirement under the law, and he is not stopped from questioning at a stage where he finds himself aggrieved. This is the law. I made representations. They kept quiet. Not kept quiet. What they did, they took a resolution sending the matter to the Honorable Governor. Governor replied subsequently that no, I have nothing to do. You decide according to the law. That happened. They issued me the letter of retirement that you are going to retire such and such. Then I came before the Honorable Court. So the Apex Court has said you can come. There is nothing. Therefore, my responsible submission, the London single judge also accepted it, but it says that reading together 3 and 9, it can be said that this condition was not appears to be arbitrary. There I am. There I am. That is not a logical conclusion. This is not a fair construction of the law. Therefore, well, the whole purpose is frustrated if that interpretation is accepted.
yes.
Animus important is that question, Malad, should be always. Let my learned friend, he is in a hurry. Yes, if necessary, I will come and reply.
My lord, on the first point of estoppel, my lord, my learned friend is relying upon the judgment, which has been explained in a later judgment of the Supreme Court. My lord, that was a case of a very low paid employee. And this present appellant, my lord, he was prior to joining the university, he was a senior lecturer of Nagaland Girls College.
You mean to say that this 2021 10 SCC has later been
Yes, it
explained?
has been explained, distinguished and explained, my lord. that is in Union of India versus 2022 2 SCC 25 and Murugation, Union of India versus and Murugation. My lord, these are all, my lord, it's not, but this proposition of law started in that Brajanath Ganguly's case, that higher bargaining power of the employer. If it doesn't suit you, don't join. It's not that you will be divested of a job. Please come to para 41, my lord, at page 52. At page 52. Mr. Prashant Bhushan made reliance upon the decision rendered by this court in Somesh Thapiyal, were of the view that it is not a case in point. In the said decision, rules were in place for a regular employment, and the post was filled up, was a bottom line post. The concept of bargaining power was thus rightly applied by this court. The grievance was also in tune with the rules. There was no justification for contractual appointment, whereas in the case in hand, we are dealing with a tenure-based appointment. Thus, fact being different, ratio has no application. So, in my lord, the case which my learned friend relied, there was a rule which governed the condition of service and terms and appointment. In spite of that, a contractual appointment was made. It was in that context, my lord, that the lower bargaining power of the employee was recognized. Unlike in the present case, my lord, he is already a professor. He is looking at better opportunities in life, my lord. Now, therefore, he is with his eyes open. Kindly see, my lord, the appointment order is of 20-10-20. He joins on 3-11-20. And after 13 months, that is on 31-12-21, he sought clarification regarding the clause in the appointment. So clearly by his conduct, my lord, he has accused, my lord. He has waived his right, even if any. Rather, he just stop. Now, coming to the, my lord, merits of the case. Now, my lord, yesterday,
Mr. Chaudhary, just
Yes.
one question. Sir. When the appellant approached the court,
yes,
was he 60 years already or less than 60 years? Any data on that?
7-8 days were left.
So he had served around 3 years.
My lord, if your lordship looks at this scheme of the statute of the university, is very clear, my lord. In case of tenure post, there will be no extension. Otherwise, tenure post is for 5 years, but there is an upper ceiling of 60 years. So Learned Singhal just said, reading section 3 and 9 harmoniously, what leads to, my lord, is the situation where if you have joined at 57, you have to retire at the age of 60. What is the difficulty in that, my lord? For example, if your lordship would kindly have the Administrative Tribunal Act, there are so many legislation in this state, my lord, where the similar provision exists. I am yet to come across an authority of the Honorable Supreme Court as is, for a proposition as is sought to be projected by my learned friend. There is none, my lord. Please come to section 8, my lord. Here in this case, there is a proviso. In our case, we have section 9. The chairman, vice chairman, or other members shall hold office as such for a term of 5 years from the date on which he enters upon his office, but shall be eligible for reappointment for another time of 5 years.
Section 8, you are reading?
Section 8, my lord, of the Administrative Tribunals Act
You are
1980.
reading unamended.
Oh, maybe.
That has been amended in the year 2007.
Anyway, my lord, I was trying to look at the purport of this section, my lord.
This
Here
now-
there is a
now
proviso.
Now it speaks about only chairman.
Okay, okay.
The chairman shall hold office as such for a term of 5 years on the date he enters upon his office,
Yes,
provided no chairman shall hold office as such after he attained the age of 68 years.
yes. Now, my lord will kindly take the statute in question. Please come to my lord, first section, page 66, on which the entire case of the appellant rests.
Yes,
The term of office of registrar, the finance officer, the deans and directors shall be 5 years, but they may be eligible for reappointment. So entire case of the appellant is based on this provision. My lord, can we, are we not supposed to take note of the other provisions contained in the same chapter? My lord will kindly see at page number 65, it is chapter Roman 4 capital A. Then my lord will kindly come to page number 70. Sorry, yes. Page number 70, the Dean Study Center. So he was appointed as one of the dean. Then my lord will kindly come to page number 80. Please come to 5 on top, my lord. The officers mentioned above shall be
Page,
subject to
page.
80, my lord. Page 80, pages are indicated at the bottom.
Yes,
of the
yes.
page. 5, my lord. Officers mentioned above,
Rule 9.
5, my lord.
Rule 5, yeah.
Yes.
Yeah.
The officers mentioned above shall be subject to such service conditions and conduct rules which university may prescribe from time to time. Then please come to 9. The officers mentioned above shall ordinarily retire at the age of 60 years, provided Board of Management in the interest of university may re-employ an officer except holder of tenure post beyond 60 years, but not exceeding 60 years. So my lord, other than the holder of a tenure post may be eligible for an extension of another 3 years. But in case of other employees of the university, which includes dean, and whereof 5 thereof prescribe the condition of service rate with 9, it says they will retire at the age of 60. So that is why মানে এইটো বাদ দিয়া ৰিএমপ্লয়মেণ্টৰ কথাটো আহে নাই। So my lord, conjoined reading of
This term tenure post has been defined here in this rules or regulations.
my lord, I have referred to page 70. It's in the same chapter 4A.
4A.
Yes, it starts at page 65. Page 65.
Yes,
Sorry, chapter 5, my lord.
chapter 5. Yeah.
Kindly see the heading, manner of appointment of registrar, finance officer, deans. We are concerned with dean and director of university, their emoluments, condition of service. It's very specific. Condition of service includes at up to what age, my lord, an officer of the university will be entitled to hold office. So here at page 7.
Is there any difference between the substantive post or tenure post? Or
My
a
lord,
regular post?
My lord, in service jurisprudence, there are 4 types of posts. One is a permanent post, one is a temporary post, one is a tenure post, and one is a supernumerary post. Fundamental rule says so, my lord. And tenure post has been defined in Fundamental Rule 30 capital A. Tenure post means a permanent post which an individual government servant may not hold for more than a limited period.
That,
Yes.
Which you have referred to?
Yes. Fundamental rule, my lord. FR Khondio. The pages may not tally. Right, but there we are. মই আরে খুব গল সদায় এই পেজ লৈ অশান্তি লাগে
Which you are referring?
1 second, man. Yes. My lord, the FR 30, my lord, 30 capital A. Tenure post means a permanent post which an individual government servant may not hold for more than a limited period.
A.
FR 30.
30 capital A.
Capital A.
30 is temporary post.
Way of officiating government service. Which?
May I
30 is-
pass over my book, my lord?
chapter or is there no chapter?
FR 38, this is FR 9. FR 9, explanation 38.
930, my lord. 930 capital
9.
A.
For 9.
I'm sorry, my lord, I said 30. 930 capital A. At page 17 of this book, perhaps, my lord.
FR 930. Page number 30.
এখন কিতাপ আছে নেকি?
Yes. $30 tenure. Time limit.
So, my lord, a tenure post is also a permanent post.
This is the tenure.
But it is limited by time.
Yes.
Then my lord will kindly come to page number 126 of that statute book, my lord. My learned friend referred to ordinance 7. I'll come to it. Before that, my lord will kindly come to ordinance 8 at page number 126.
Just a minute.
না না আগে পেজ তো দেখাবো লাগবে না হেডিং হেডিং
Yes.
Please come to page 126, my lord. Ordinance 8. Ordinance on recruitment, condition of service, workload, and leave rule for professor, reader, regional director, lecturer, assistant, and other officers of the university. No person shall be appointed in any of the posts mentioned below without fulfilling the requirements mentioned against each post. That is, my lord, here dean is also included. Now, my lord will kindly come to page 134. clause 12 on top. Teachers, officers, and other employees will retire at the age of 60 years. The university can consider re-employing a superannuated teacher according to the existing guideline framed by the UGC.
You're referring to page?
134, madam, on top. It's part of the Ordinance 8,
Yes.
which lays down the condition of service, amongst others. Teachers, officers, and other employees will retire at the age of 60 years. The university can consider reemploying a superannuated teacher according to the existing guidelines framed by the UGC. So therefore, my lord,
Yes.
my humble submission is reading section 3 with 9, read with clause 12 of Ordinance 8, which amongst others lays down the condition of service, which specifically states that the age of retirement of a tenure post is 60 years. My lord, the learned single judge was absolutely right in giving the construction to the provisions, my lord. Learned single judge has not committed any wrong. On the contrary, it is the petitioner, my lord, who has not tried to correlate the various provisions, my lord. Now, my learned friend is relying upon Ordinance 7. Please come to it, my lord, once. At page 121.
Yes.
Now, before that, your lordships will kindly come to the very preamble part. Ordinance on appointment on contract basis or fixed tenure contract basis. It is not the appellant's case that he is holding any contractual or a fixed tenure post. Sorry. Yes, he is holding a tenure post. My lord, in service jurisprudence, tenure post has got a definite connotation, as has been expressed in section 3. Now, my lord, this is framed under section 23(1)(d). Please come to 23(1)(d), my lord. At page 26. At page 25. Page 25. Section 23(1). Now, D was deleted, my lord, and it was renumbered as C. In other words, C is a residuary provision, my lord, in my humble submission. Subject to the provisions of this Act and statutes, ordinance may provide for all or any of the following matters, namely, the admission of learners, course of study, and the fee to be charged therefore, qualification pertaining to degree, diploma certificates and other courses, conditions for grant of fellowship, award, and the like. Now, if your lordships would kindly come towards the bottom of page 26, now kindly see, omitted the original clause C as quoted below and clause D related as clause C by Assam Act of so and so. But it is something to do with absolutely some other purpose, my lord. C, in my humble understanding, is a residuary provision. And in any case, we are not dealing with a case of a contractual appointment, my lord. We are dealing with a tenure post. Therefore, my lord, on the whole, my submission is the learned single judge view that section 3 and 9 read with clause 12 of Ordinance 8 has to be read harmoniously to extend and construction is absolutely correct, my lord. And there is no infirmity in the view taken. And I don't think, my lord, the appellant has been able to make out any case. That's my answer. Deeply.
Now, let to reply the points raised by my learned friend. First thing, the definition of a tenure post. Lordship has seen that. So it is for a limited period. And the period is prescribed here as 5 years. So there is no dispute to that extent. It is clear. And who are those posts? Can you once more look into? That's why I said, my lord, regarding officers, 9, to my humble understanding, is to be construed by looking into the scheme of officers. It is true, it has come in the same chapter, but again, it leaves the scope to distinguish as its application in respect of which particular group of officers. That your lordship will find. Therefore, I will first take your lordship to here. For application of the law, statutes and all, those are there. One is subservient to the main act, then the statute, then the ordinance. Now, what the main act, the founding act, on the basis of which the institution was founded, what it says regarding officers, kindly look into the particular provision. It is page 23 of the book. 23 of the book, officers, 7. Page 13, perhaps, may look into page 13, my lord.
Yes,
Page 13, it starts with officers of the university. This is the law, my lord, which brought the institution into existence. It says, the following shall be the section 7. The following shall be the officers of the university. Who are they? Vice Chancellor, the Vice Chancellor, the Pro Vice Chancellor, the Registrar, the Dean Academic, the Dean Administration, the Dean Study Center. This is where I am. The Finance Officer, the Director, Multimedia Course Material Center, the Director, Computer. Then kindly note 11. Such other officers as may be declared by the statute to be the officers of the university. Here lies the difference. These first 10 category of officers have been so declared already by the Act. They are the officers. And such other officers as may be declared by the statutes. There are other officers declared by the statutes. Now kindly come to that statute. Before that, lordship may also take note of section 12, page 17. Page 17, my lord. Dean, the Dean, section 12. Every Dean shall be appointed in such manner on such emoluments and other conditions of services, and shall exercise such powers and perform such functions as may be prescribed by the statutes. So this is regarding the Dean. Then other officers, kindly come to 18, page 18. It says, section 15. Lordship got it, my lord. 15, section, other officers, heading goes, the manner of appointment, emolument, other conditions of service, and powers and duties of the other officers. I will indicate, I will refer to other officers, my lord. They have termed it as other officers. Other officers of the university shall be such as may be prescribed by the statutes. Now, regarding the statutes, kindly come to page 23. Chapter 5, it speaks about statutes, ordinances, and regulations, how they will operate. Statute, section 21, subject to the provisions of this act, the statutes may provide for all or any of the following matters, namely manner of appointment of the vice chancellor or the term of his appointment, emoluments, other conditions. This is regarding vice chancellor. Then B, this is relevant to us. B, the manner of appointment of registrar, the finance officer and other officers, the emoluments and the conditions of their service and the powers and functions that may be exercised and performed by each of such officers. So says that the statute shall provide. Statute shall provide. Then the statute was made. And the ordinance says, ordinance regarding, the ordinance, Lordship may kindly come to 25 page. Section 23, 1. Subject to the provisions of this act and the statutes, the ordinance may provide for all or any of the following matters, namely admission of learners, the course of study, and the fees to be charged, therefore, the qualification pertaining to degrees, diplomas, certificates, and other courses, the conditions for the grant of fellowship, award, and the like. This is regarding the admission, course study, and all that, fees and all that. It comes under the ordinance regarding the internal conduct.
What about C?
C, any other matter which by this act or the statutes is to be or may be provided for by the ordinances. Those which are left out, not mentioned in the statute, nothing has been said, ordinance can make it. That is my clear, to me, I understand it in that way. So therefore, it can be provided for unless something is said in the statutes. You can provide. Now, whether the statutes has provided it or not, that is to be foreseen. Now kindly come to that statute. Page 65 once again, my lord. Kuntu?
29.
Yes, it. Oh, it was Rahim Baruch, sir. 65 once again, my lord. Yes. So,
Yes.
my lord,
Yes.
here, before I take your lordship to chapter 5, lordships may be pleased to see also chapter 4A. This relates to pro vice chancellor. Here is the provision. Lordship yesterday, Lordship Chief Justice read it, referred to me also. There is one that provision I'd like to indicate. Here it says the pro vice chancellor, the term of the office of the pro vice chancellor shall be 5 years and shall retire at the age of 60 years. Clear provision. I want to submit before your lordship that the statute wants to make it clear whenever the authority wanted a particular officer to be retired at the age of 60. So pro vice chancellor, though it is said that he holds a term post, tenure post, he should retire at the age of 60. Specifically made. Now come to chapter 5. Manner of appointment of registrar. First kindly see, my lord, this heading. Registrar, finance officer, deans, and directors of the university. This relates to these officers. This provision relates to these officers only, including deans. That means those officers which were already declared by the act itself as officers of the university. This chapter takes care of first the officers which were already declared by the act as the officers, not the other officers. Other officers are not taken care of. Here it says manner of appointment. shown that it must be advertised, scrutiny, all that, including, then the B, post to be advertised, applications received, there should be a committee which they will scrutinize, interview taken, then only up to my lord, 1A to G. After obtaining the approval, the vice chancellor shall appoint the persons in order of preference. This is the procedure prescribed. So all these officers are to be recruited by following this. Now, then it says emoluments. What can be for these officers? Term of office for these officers, it is very categorical. The term of officers of the registrar, it doesn't say, my lord, the officers. This particular clause doesn't say the term of office of the officers. No, it says term of office of the registrar, the finance officer, the deans and the directors shall be 5 years. But they may be eligible for reappointment. It is very clear, my lord. Now, they can be reappointed. An appointment always by following the due process. Then powers and functions, kindly see. Powers and functions of the registrar. Rule 4 says A, Lordship will kindly bear with me and go ahead with further. A, B, finance officer, next page, my lord. 69 page, the dean academic, C, it is C, heading C. Then heading D, next page, 70, the dean study center. This is regarding study center. It says the dean study center shall be a whole-time salaried officer of the university and shall perform these functions. This is there. And then kindly see E, down below, the director multimedia course materials center, E, up to heading E. Then F, the director computer. This is how it is there. Then comes G. This is important. G, it says other officers. Who are those other officers? These up to F. Up to F, the officers already declared by law. Then it says other officers. G starts with G, capital G. It says the controller of examinations, deputy registrar examination, deputy registrar academic, deputy registrar finance, deputy director study centers, assistant registrars, assistant controller, the assistant librarian. They are called other officers. There says the following shall further be the officers of the university. They are declared by the statute. Statute declares them on the basis of the law. Section provided, section 7. There may be other officers as may be declared by the state. Now, then it says manner of appointment of these other officers. What is the manner of appointment of these other officers? GA, page 72. It says the qualification required for the above post shall be fixed by the vice chancellor with the approval of the board of management. 2. The procedure prescribed for appointment of officers in clause 1 of this chapter shall also be followed in making appointment of these officers. That means the same process of recruitment shall be followed in case of recruitment of these officers, these other officers. It says, then duties and responsibilities of these officers, emolument B, then C. Well, this comes under clause G. Under clause G, all these are prescribed. B, C, duties and responsibilities. Then 2, deputy registrar. These are officers, ordinarily officers as we call ordinary employees of the university. Those who will work till
You
60.
mean to say that rule 9 speaks about these officers and
Exactly,
not
man.
about that? We
Not about
understand.
that.
That we understand.
That about. Malad, this says, because section 3 says, these officers, up to all that, their term is 5 years. They may be reappointed. And the other officers, that I'm grateful to your lordship, that is my contention that this 9 says that the
Speak
other
about
officers,
the other officers, not about the vice chancellor, finance and so, dean and
so,
everything.
dean and all, not
We
so. They will retire at 60, but they can be re-employed. Kindly see the distinction of the two words used. One is reappointed, one is re-employed. Connotation is different. Therefore, my respectful submission, the Rule 9 makes it no confusion. There should not be any confusion. That is why my contention is that the other officers, for them tenure is not prescribed. But in case of pro vice chancellor, tenure is prescribed and says, no, he will retire at 60. And in case of other tenure holders, they will leave the post on completion of the tenure unless they are reappointed. In my respectful submission, in my humble understanding, this is the scheme of the law. Because, my lord, there are the officers, those officers already declared by the Act. They are taken as experts in particular domain. They are taken in for a particular period so that they can provide sustenance to the university in formulating schemes, implementing all that, guiding the institution. And then these expert services obtained, if not required anymore, they can be released. But there is a provision for this post. But other employees who are always required to implement the schemes, to implement the programs for the good running of the institutions, they will do all the other jobs. They are the other officers.
Yes.
Therefore, my response submission. That aspect, the learned civilians didn't consider.
Yes.
That aspect did not consider. Then, regarding, Lordship pointed out, my learned friend also pointed out, Ordinance 7.
121. 121.
Hmm?
121.
Kindly come to page 120.
Yes.
My lord, page 120.
Yes.
This is under section 23(1)(d) of the Act.
Yes.
We have read already. Here, ordinance on appointment on contract basis or fixed tenure contract basis. My lord, conceptually, all appointments are contractual. But there might be a fixed tenure, where it is a fixed tenure 5 years, tenure post. Therefore, this comes in particular sector, this particular ordinance. But it has specified one, appointment on contract basis, appointment on all categories of staff. It speaks of staff, namely academic, professional, or technical and administrative shall be made on contract basis, on principle. Tenure of appointment, the tenure of appointment on contract basis shall generally be 5 years or as may be decided by the Board of Management by Vice Chancellor. My response submission is, I am referring to it, it gives the impression that even those purely contractual posts also, there may be a fixed tenure of 5 years and they will continue till then. This says, and in case of the officers like me, in their case, Rule 3 has made it specifically clear it shall be 5 years.
So this ordinance 7, the provisions of ordinance 7 has no application in your case.
Exactly. And also Ordinance 8. They are referring to Ordinance 8.
That is also not.
That is also has no application into my case.
Fine.
That is my response submission.
We understood.
And kindly, my lord, one more thing. Yes, no. Oh. My lord, I need to answer the argument advanced by them that distinguishing that Sumesh Thapliyal's case, that I cannot take the advantage of saying that I have no bargaining power. My lord, in my response submission, that is not sustainable in law. Your lordships will consider, please, what was my position? I left my job there
Where?
No.
in Nagaland Girls College. I was the associate professor there. I was there when I was told that in the second time, for the next term also.
You were in the very same university from 15 to 20.
Sorry, Mal.
From 15 to 20, you were very much in this university.
Yes.
University
There is a
and
second.
on Lien.
He was on second.
On lien. On the earlier term, from
The
15 to 20.
appellant was on second term
Yes,
as dean.
yes.
When was the first term period between?
2015 to 20.
2015 to 2020.
20. So what you are arguing is that he left the job from where you have left job? You were here in this university and again you. were
No, Mala, I was on lien.
Almost a lien.
Yes, I was on lien. On lien only I came. And when for the second time I was selected, if I continue here, I cannot retain the lien. I am not entitled to.
Your
What is
lien
the
came
age
to
of
an end.
retirement there?
Sorry,
What is the age of retirement in Naga College?
60 years.
So if
60
you were
years.
there, you would have retired in 60.
I would have retired in 60 years. So I opted for that. When I am selected here, if I join here, I will get few years more service to render. And though I had to relinquish because I am otherwise not entitled to lien. I had to relinquish. I said that please release me. I am not continuing there. They release me. And I am to join here otherwise. That is why my position. And kindly see, my lord, also, when I am there with the administrators, one of them, I may say, I can always take it before the authorities. How is this that this is coming up? I said this. And why should I immediately go against them? I pointed out to them. Working together in the same table all the time.
As per your government, they assured you that they will clarify
Yes.
this. Yes.
We'll look into it. Please wait. This has come in. We'll look into it. Wait.
So if your argument is accepted, when is your client going to demit office? When will he
On
complete
officer
5 years?
term, my lord, 5 years term.
When? Which date?
25.
211.
Which date?
2/11/25.
2/11/25.
2025. That is the penultimate day when I will have to vacate.
So now it is about 1.5 years.
1.5 years.
That is at stake.
Yes. That is only. I'll have to go. Thereafter I cannot claim. So my full submission, ultimately when they forwarded my representation to the authority, they didn't take the call, rather issued the notice. At that stage, I am bound to come. I am bound to come, and I came before this honorable court.
Yes.
Therefore, in my full submission, my lord, there is no ambiguity in law. There is no ambiguity in law, but the learned single judge construction is ambiguous.
Yes.
My humble submission. Lordships will be pleased to continue. Deeply obliged.
Argument, sir. Judgment reserved.
Obliged.
Daily list for orders, item 2 and 3.
If the matter may kindly be passed over for the time being.
Two issues, my lord. One is compensation amount, and second is the action against the hearing officer.
You referred the matter to this for assessment, whether the assessment.
Lots of the instructions we have received, Lordship. Need to know. Sanction has been.
Now, you have already assessed.
Yes, my lord.
So when you are going to make the payment?
My lord, it is sent for financial approval, my lord.
Yeah.
My lord, last line, your lordship may kindly see. Now concurrence from finance department is awaited and will complete the payment of compensation as and when concurrence is received. My lord, it will supposed to be received within a short time, my lord.
The expenditure is debitable in the head of account, so and so the proposal is uploaded, government. This proposal has been uploaded. Where is that, that it is pending with the,
Next page, my lord, finance department.
next page, which page?
My lord, the second page, my lord, the
Page-
amount has been indicated, my lord, page 242.
Yes, amount you have indicated 10 lakhs, 2.50, 10.8, these 6 persons you have quantified the amount or determined the amount, yes. But where does? But you have sent it to, and the proposal is pending with the finance
Finance
department,
department.
where it is mentioned in this order. The 24th of April 2024, where it is mentioned. Within a period of the expenditure debitable head of account, the proposal has been uploaded, government submitted. In the critical of- What happened then?
Yes, yes, okay. It is, my lord, online, my lord. Pension proposal for
Concurrence has been moved to the finance department on 30th of April. Now
But-
concurrence from awaited. You are not from the finance department.
No,
Who is
my
for
lord,
the finance department?
has a separate standing council, my lord.
Is not party here in this petition?
No, your lordship.
No, my lord.
Who is for the finance department? Call him. We'll give him this and direct him to take instruction.
Lord, after this, the next issue comes is with regard to, my lord, what action has been taken against the erring officers? Because there was an undertaking given before this court that,
They have already filed a criminal case for that.
Lord, that nothing.
That was on the last occasion, this was there.
My lord, because the committee's, my lord, recommendation was placed before your lordships in a seal cover, my lord. So I was
No.
not privy to
I
that.
think so it was.
There is no,
First,
On the last occasion,
on
your
the first
lordship.
point, let's
fine, my lord.
have the compensation and then we'll.
That's correct. my
Yes,
lord.
my lord,
That's
on the
correct.
last occasion, also
This is
your
what
lordship
the-
expressed this, my lord.
You are for the finance department. Who is for the finance department?
Mr. P.
So where is he? Call him.
This is,
Call him.
Matik.
वो जब आए जो बताना.
Obliged. Your lordship, there's a tag item in item number 2, WPC 239/24.
Yeah.
Your lordship, I'm appearing on behalf of the petitioner. She is the wife of the deceased.
Item number 3,
Yeah, item number 2, there's a tagged item. Sorry, your lordship, item number 3.
Rashida Khatun.
Yes, yes.
Yeah, what do you want?
I'm appearing on behalf of the petitioner, your lordship. She is the widow of the deceased who died in the custody of the Bhaktapur police station.
Yes.
And what your lordship are dealing in the PIL is the outcome of that whole incident of because of this death. Your lordship, we are seeking compensation by filing this writ petition. She is a widow having 4 minor children. Her house was bulldozed, your lordship. She is on roadside, your virtual lordship, and we have to pursue her to make this writ file, your lordship.
That is the scheme of the government where the compensation is required to be paid.
Well,
Mr.
both-
There is
both
a scheme of the government.
Well, both the item number 2 and 3 are connected, my lord. In fact,
No,
both
no,
item
no,
2 and 3 are
Yeah,
connected.
not your
in
lordship.
relation to the same incident.
Yes, yes. in the same-
Custodial death of one,
Yes, yes.
No.
yes.
But,
What is your response?
we are awaiting the instructions in this matter, my lord. We'll file an affidavit in the matter.
This matter is pending since long and still you are awaiting. What is this?
But some instructions, in fact, in the meantime, regarding the whole incident, an inquiry committee was, my lord, constituted.
That
Report
we
has
have
come.
already taken into
Yes, yes,
consideration.
The report has come and as per the report, now the government is taking action. That is why Lordship has take the matter
So
with.
far as regarding compensation to this individual lady. On account of custodial debt, what do you want to say?
Malad, I'll file my affidavit Malad in the matter. Malad. Kindly give us affidavit.
Let them pay interim compensation of 10 lakhs. You pay interim compensation. You're not denying or disputing that he died in the custody.
But-
That's the finding of the inquiry also.
But as per the inquiry report, the government is taking action and we have already placed that. as regard the
That's
house,
only
we have
you
already
found
sanctioned
that
the
your
amount.
officers were
But-
guilty
Malad, that is also under consideration. Malad. My instruction is that is also under consideration.
on
that
account
as
of
regard the hiring
this
officers were taking
custodial
action.
death of Shafiqul Rahman
Lord.
or whatever his name is.
Lord.
Some dispute arose, people collected there in the police station. They tried to do whatever they created ruckus there, and thereafter the police has bulldozed the house of those people. That's why only this whole incident took place,
Malad.
and this inquiry was ordered.
Well, as per the inquiry, they have taken action. Some amount has already been lodged. We have already placed the instruction. Kindly give
What
us
about
1 week's
this
time, Malad. 1 week time,
Compensation
Malad, file
to
the-
this individual lady.
Malad, as regard that, Malad, kindly give us 1 week time, Malad. We'll file the affidavit in the matter, Malad. What action they have taken, Malad, in the matter.
What action means is about compensation.
True, Malad. That is what,
It's a
Malad,
question coming under Article 21 of the
that,
Constitution.
that is what, Malad, the inquiry report has.
How much compensation you are paying? That's the only thing we want to know.
Malad, let me have the instruction, Malad. That is what, Malad.
So
I
what
need
was,
to
what
file
are
the
you
affidavit.
doing till date? It's the petition is of January 2024. Still you have not filed any reply. What is this? You have not filed any response, then
But-
certainly we have to direct that you pay interim compensation and then file
Lordship,
your
I-
reply.
Lordship, may kindly consider, Malad, that in the meantime, the inquiry was there, a committee report has come, government is taking action.
What,
Malad. Kindly-
what do you want to say? Whether you are supposed to, you are willing to pay compensation to this lady or not? That's the only thing.
Malad, I pray for 1
The
week.
prima facie of the opinion that certainly she is entitled for compensation.
Malad, that is, Malad, I pray for 1 week time to file the affidavit to that extent, Malad. Let me have, Malad, the inquiry report is with them, Malad. Let me have an opportunity to file the affidavit. Malad.
उसको segregate करते हैं।
Who is for the finance department? I am Mr. Advocate. You are for the finance department.
Yes,
Now there is a proposal for paying compensation to 6 of the persons. The assessment has already been complete regarding the damages. And the matter is pending at the end of this finance department. You complete your instructions when you are going to pay the compensation to these persons.
If it is already before the finance department, 1 week will be sufficient.
Okay, fine. Okay. Learned counsel appearing for the political aid department. You are for the political aid
I
department.
am for the home.
Political aid department
am.
has submitted that the determination of the compensation has already been completed. And the amount to be paid to the 6 of the persons whose house were demolished has already been calculated. It is submitted that a proposal for paying the compensation is pending with the finance department. Full stop. Learned counsel for the finance department to place for and granted a week's time to apprise this court that by what time the compensation would be paid to the affected persons pursuant to the proposal sent by the political aid department. Full stop. This you noted in the writ petition PIL number 3/22. Now heading there WPC number 239/2024. This petition is filed by the petitioner whose husband was subjected to custodial death, for seeking appropriate compensation from the state of Assam. Full stop. Despite service of notice upon the state respondents, no reply to the writ petition is filed. After a long time, despite a long time, learned counsel appearing for the state, Mr. D. Nath, is granted last opportunity to file reply to the last opportunity of a week time to file reply to the writ petition.
Landed government advocate to also obtain why the court could not carry interim company.
Learned,
Mr. The custodial death is not explicated.
Mr. Dina is further directed to explain why during the pendency of this writ petition, to explain that why not the interim compensation be granted to the petitioner during the pendency of this writ petition. Full stop. List both these writ petitions on. Ari follow up, you have to file reply.
My lord,
And you have to complete your instructions,
Lordship.
counsel for the finance department and make the payment at the
Lordship.
earliest. Ask the finance department to make the payment at the
Lord.
earliest.
on 13th, my lord, 13th, my lord, I think.
13th,
Mr. Nath, two things. Inquiry report admits custodial death. This is a clear case of vicarious liability of the state. Therefore, you better come clean on that.
That means can you fix on 14th? Lordship, that means can you fix on 14th of May?
Item number 5.
May please, Lordship. Lordship, I appear for the respondent number 7 in this PL. I seek some more time to file my affidavit in
who is the
opposition.
respondent number 7?
I am the Vice Chancellor. I have been included as a by name.
Sir,
Lord.
what's your grievance in this writ petition?
Lordship, it pertains to payment of excess remuneration to the
Deputation allowance to this vice chancellor.
Lordship.
How this is a PIL? You're agreed by, this is your personal grievance? How every citizen of the state of Assam is agreed by it?
Lordship, I am an outsider completely to
What
the.
is the outsider? How you can file this PIL? You may challenge it before the, by appropriate remedy of filing a writ petition if it is maintainable at all. How is the PIL? PIL can be maintained on this point.
Since-
Tomorrow, you suppose that if any person or any employee in any department is getting some undue, whatever the benefit. So any person can walk away, can walk into this court and say that this is a PIL, so you entertain it. What is this?
Since it is public money, my lord.
Whatever it
so-
may be
And it
public
is
money,
amounting to
no
more than
much.
28,000. every
PSC
month.
committee, approach the PSC committee of the assembly.
Yes,
If you are so, they approach the public accounts committee of the Assam State Assembly. They will look into this.
We have approached the chancellor, my lord.
Plus, in fact, he has filed another PIL challenging my appointment also. That is also pending, Your Lordship.
No, there is the public accounts.
maybe a writ petition of core and co, we can
Yes, sir.
entertain it or not, but so far as regarding this petition can't be treated as a public interest petition, sir. That is absolutely.
Lordship, I will make my submissions on that respect, if your lordship permits, because I'm not prepared in that regard. It's
Leakage.
just
This writ petition is filed by the petitioner.
Huh.
With the grievance that the respondent number 7, Vice Chancellor of AAU Jorhat is getting undue benefit apart from its salary such as deputation allowance. Deputation allowance per month. Full stop. Prima facie, we are of the opinion that the dispute, the grievance raised by the petitioner in this petition cannot be termed as a grievance of public at large. Hence, we have doubt about the maintainability of this PIL petition. Full stop. Para. Learned concept of the petitioner prays for some time to satisfy this court about the maintainability of this PIL petition. time frame for is granted, how much time would you,
2 weeks, my lord.
just after 2 weeks?
No,
In the
may I pray
meantime,
that-
you may file your response.
But there is another PIL challenging my appointment. Can I pray that this matter will be tagged along with this?
That is altogether.
Item 6.
Item 6, I'll prefer such adjournment matters. My arguing counsel, my senior my lord, has to leave outstation due to some medical issues, my lord.
Lordship, I have a submission, my lord. There is a delay of, my lord, 1,532 days, and there is no even any application for pondering the delay along with the appeal.
No.
Delay of, my lord,
My lord, we are
1,532
against order passed in review petition, my lord. That limitation issues raised in that review. The review is dismissed and because of that we are here, my lord. That will be sufficiently explained by my senior, my lord. See, he's on leave on medical issues. Cause, my lord, can you
Raise
be?
an objection to the counter,
Yes, I have already filed, my lord.
already filed.
Yes, my lord, on
Let it come after 2 weeks, my lord.
We'll consider it,
my lord.
whether it is banned by limitation. क्या कोई सब लड़ कौन से पता प्लान लिस्ट ऑन
Publish.
Item 7.
May I please do that? Lordship, in this matter, kindly pass over for the time being, our Mojumdar will appear, my lord, here.
What happened? Whether this proposal is cleared by the director or not?
Affidavit filed by the director, lordship, may kindly pay space 50, lordship.
Last time
Lordship,
we have observed that.
lordship.
My lord, the education to comply with the order, what happened?
Yes, my lord. My lord, after that order, my lord, a communication has already been made and thereafter, my lord, director wrote a letter to the secretary for necessary instruction, but till that, my lord, thereafter, no development has happened and moreover, my lord, on 2/5/2024, my lord, secretary issued a letter to the director where asking whether the petitioner were rendering service during their termination period. So, my lord,
That is the court's order.
lordship, direction or specific direction was to provide the area of that very period, lordship. On last occasion, lordship has allowed us to, in similar situation, lord, to approach the government, lordship.
Yes,
Lordship, that order is here.
that gives.
In this regard, my lord,
In the meantime, we may approach.
one additional affidavit of what the steps has taken by the director, my lord.
You have filed
Yes, my lord, one additional affidavit has been filed, my lord.
when?
It is, my lord, on 25/4/2024, my lord.
Then counsel appearing for the respondent has informed that the director of that the present respondent has already recommended the matter for the purpose of making compliance of recommended the matter for the purpose of complying with the order passed by this court to the secondary education department. It is contended that the matter is pending at the end of the secondary education department. Full stop. Taking into consideration the said circumstance, the grant liberty to the petitioner to approach the secretary, education department, government of Rajasthan with the prayer, government of Assam with the prayer to act on the recommendation made by the director secondary education. When you have referred the matter to the secondary education.
My lord, one is 9/10/2023 and another is 18/4/2024, my lord.
Pursuant to Assam with the prayer with the prayer to, Kalika, with the prayer to act on. Made by the director of medical health. Oh, what is the director's name is? Name, what designation? Director of secondary education, she is the, just by the director of secondary education. Dated
That is, one is my lord, 9/10/2023,
9/10/2023.
and another is 18/4/2024.
18/4/2023. The petitioner may approach the secretary, secondary education within a period of 10 days, list after 4 weeks, along with contempt case number 589/2023.
It is not Secretary School Education Department.
Secondary,
Secretary School Education Department.
school education लिख देना हो, जहाँ पे education है वहाँ पे school education.
All right.
Item 8.
Well, the I for condonation of delay, there is delay of 171 days, my lord. And the
Yes.
respondent has appeared.
Yes, Mr. Concept.
They appeared. I understand, my lord, in some of the connected matters, delay has been condoned.
The delay is condoned
Lot.
and writ appeals have already been admitted.
Yes, my lord. Only they will submit a copy of the appeal which is
I'll submit a copy. No, thanks.
I have not received that.
The matter
I'll-
comes upon for consideration of the IA number so and so with a prayer to condone the delay of 170 days. When counsel for the petitioner has, applicant has submitted that in connected appeals, the delay has already been condoned. And that in the identical appeals, delay has already been condoned and matters and the said appeals have also been admitted. When counsel for the respondent is not in position to dispute the said fact. In such circumstances, the application under section IA number so and so is allowed, the delay of 170 days is condoned. Or registry is directed to connect to register the connected appeal and list it before this court after 10 days
My lord.
for admission.
Copy.
Item 9.
Well, in item 9, we have taken steps, but we could not file the dusty affidavit because it has not returned. Can you allow us to take fresh steps my lord, in the matter?
Then concept with the applicant prays for and granted time to take fresh steps for service of notice on the opposite party
Number
by
one.
the state as well as through registry with AB within a period of 1 week.
My lord.
On
Lordship.
doing the same, let notice be issued to the sole respondent returnable on so and so.
My lord.
Item 10.
Well, in item 10, my lord, the respondents, they appeared and lordship has also admitted the appeal, my lord. Now.
This is
if I may please
already
allow with-
the
it is
same
admitted.
matter
Same, my lord, similar matter. My lord.
when it was admitted,
My lord, on 20th of February,
20th of February. Why it is? The matter is, the service is service is complete, matter is admitted, list
Right.
for hearing in due course.
lordship. Honorable.
Item 12.
May it please, my lord.
Yes,
My lord, sir, appeal against, my lord, an order passed by the honorable single judge, my lord.
who
My
is
lord, this
appealing
is
for the
regarding
respondent?
base school status, my lord.
Who is appealing for the respondents
I am for the state response, my lord.
and who is for the respondent number 7?
My lord, the school, my lord, we have taken steps, my lord. The Karahan High School, my lord.
What happened?
It's not taken. You have not taken steps for service on respond number 7.
My lord,
In fact, he is not the respondent in the proceeding, my lord.
Petitioner. Necessary party. What is accepted?
Petitioner है उसको।
Not everybody. Full management committee file so it's
हाँ, ये applicant कौन है?
appellant one.
अगर full है।
মই পদ্ম দত্ত টিউটৰ অফ বাহু জালজালবাৰী
বাহুদাল তেৰা নাছিলে party।
কৰা নাই কিন্তু ইয়াতে কৰি আছো মই
What, you have not taken any steps?
the steps we have taken my lord
When? Steps for issuance of notice has not been received by the concerning section till date. And acceptance notice filed on 15/3 has been received. Yes, to-
yeah separate file here yeah government advocate respondent number 7 I think will be a private person
ये कभी नहीं लिखता है
school
ये।
management
ये फर्स्ट टाइम आई सीन दिस काइंड ऑफ इसके बारे में लिखा था देखिए पता नहीं नया नया
नया बाबू आ गया, कुछ करते हैं। You have not taken the steps, mister. On which date you have taken the steps?
my lord kindly some time may be given to me I should
Litigation and the concept of the applicant pays for and granted time to take steps for the purpose of serving notice upon the respondent number 1. Time period for is granted list after 2 weeks.
Item 13.
mobilize my lord
May I please, your lordship? This is a condemnation petition, lordship. On last occasion, lordship issued notices, lordship.
What happened? Who is appearing for the?
I am paying for the respondents, lordship. I have no objection in delay part, lordship.
You have no objection.
In delay part, lordship. Delay part.
What's the controversy is about?
Lordship petitioner.
You are appearing for all the respondents?
Lordship. Home department.
Yeah,
All department. All the respondents, 1 to 7.
one 173 days.
173 days. 173. मैंने कही मैंने किसी बात কথা বলে গেল এখন ফিরে আগে আগে যেটা তো
What do you want to say on merits?
Lordship.
Merits.
Merit, lordship, at this stage, lordship, he has served the sentence also. dismissed from service, Lordship. At this stage, Lordship, I'm praying for compassionate pension, which is there's a scope for that.
Compassionate pension,
And-
there was no such prayer before the learned single judge.
Single just that is not there, Lordship.
That is not there, then how can we even consider it?
Lordship, Rule
What do you
20.
mean by compassionate pension? You were convicted, your conviction was maintained up to High Court,
Yes, Lordship.
then what remains?
No, Lordship, there is a scope for a rule under Rule 24, Lordship. of
But where is such argument?
No, Lordship, at that period,
You prayed before the learned single judge reinstatement.
Lord,
That has been denied. Where is the question of compassionate pension?
no, Lordship, writ petition was pending when he completed his conviction, Lordship. Thereafter, it
So
was
that is
dismissed,
a fresh cause of action. You file a fresh petition.
Lordship.
Whether you have prayed in that petition that this alternate prayer for compassionate pension,
No, at that period of time, it was not.
then certainly if it is there is no such pleading, how can we even entertain this? You withdraw this and if any cause of action arises to you, may file fresh petition.
Lordship. In that case, I will withdraw this appeal and that liberty may be given to us to.
Learned, this matter, this IA number comes for, IA number so and so comes for consideration of the prayer of the applicant for condoning the delay of 173 days in filing the connected appeal. Full stop. The appellant, the applicant, the services of applicant, the applicant was working as a constable, however, his services were terminated. Wide order dated, which order? Wide order dated 9/4/2007,
7.
as he was convicted and sentenced by the competent criminal court for the offense punishable under section 376/34 IPC. Full stop. The applicant approached this court seeking reinstatement on the post of constable. Full stop. During the constable, the writ petition came to be dismissed by the learned single judge by order dated 22nd of August 2023. Then counsel for the applicant has submitted that now the applicant submitted that the applicant is not challenging. The applicant is praying for compassionate pension as per the rules. Full stop. Para. Taking note of the above contention of the learned counsel for the applicant, we are of the view that since no such prayer, that's since we are of the view that the prayer for compassionate pension was not there in the writ petition, this question cannot be considered at this at the stage of at the appellate stage. Full stop. The applicant, if so advised, can very well seek appropriate remedy for the said relief before the appropriate forum. Full stop. At this stage, the net concept of the appellant has submitted that she wants to withdraw this IA as well as the connected writ appeal with liberty to avail appropriate remedy available to the applicant. Dismiss with liberty as prayed for. The IA, in view of the above, the IA number 851 and the connected appeal are dismissed as withdrawn with liberty as prayed for.
Item 14.
Well, there is a delay of 107 days, in preparing the appeal. This come for the first time,
Why the delay?
Well, because of his financial difficulties. He's been out of job since 1999, It was dismissed in 99,
Now that is over.
Well, no, not as over, He could manage, borrow and manage some money, to meet the cost at least, That's paragraph 2,
Yes,
Lordship, the notice has been issued,
we are appearing for
all the
All this
respondents.
one.
all the respondents. So what do you want to say on merit?
Yes, my lord.
On delay?
Yes, my lordship, the notice issued.
Okay, deem it, we have already issued the notices. What do you want
We
to say?
will file the objection, lordship, give us some time.
Seriously or just for the sake of filing objection?
No, no, my lordship.
Notice. Ms. So-and-so put an appearance on behalf of all the respondents. Service is therefore complete. She placed some time to file. Counter to the IA, time period for his rapid response.
Item 15. So application for condoning 105 days delay, There is already a cross appeal by the corporation, which has been admitted.
Notice. Reasonable on so and so. That's registered. That twice on so registered post and AD, that's the also.
For admission, item 16.
So this is appeal by the revenue against the order dated 4/8/2023. What's it here?
This similar question has not already not been answered.
Lordship, recently on 30th of April, Supreme Court has passed in judgment
Yeah.
where it is stated that if the label is different, then it will fall under the category of manufacturing. But here, Lordship, the respondent, they are manufacturing parts of syringe in their another unit in Guwahati. They are assembling it, Lordship. So probably
So that would mean that this assembling is the part of manufacturing.
Lordship, in our assembly, this doesn't fall under that category, Lordship. The notification,
They are manufacturing somewhere else and assembling it here.
Lordship,
And you are
1990.
treating this procedure as a manufacturing.
No, we said that it is not a manufacturing. They are not entitled to exemption under.
Okay. You said that it is not a manufacturing and
Yes,
therefore not entitled for exemption.
Exemption lots. This is our contention. But in 1995.
As per this unit, यहाँ manufacture होगा तो ही exemption है। ये बाहर से लाके या
Lots in 1995, this similar type of question came before the Honorable Supreme Court. Lots of paragraph.
So we have framed some question of law in similar matter or what?
Lots of similar matter is not there. This is only one matter. Where the appellate authority as well as the CSET, which means the appeal. What's the paragraph 18, 19, 24, and 30?
18, 19.
Lots of.
This was not brought into the notice of the CTET.
Lordship, it was placed before the appellate authority, but it was not taken into consideration. Some other judgment was
They are
taken.
distinguished or what?
Lordship,
They are distinguished in judgment or what?
this is judgment of Honorable Supreme Court. It was
They, this tribunal has distinguished it or even
no,
not as
Lordship, it was not taken into consideration. The tribunal taken into consideration another judgment.
ignored. This judgment was ignored.
It was not taken into consideration. And some other judgments were taken into consideration. One judgment, Lordship, that was overruled. That was taken into place by the revenue. Lordship, recent judgment passed by the Supreme Court, probably there is a difference, and this judgment was not taken into consideration.
So far as regarding what is this payment of interest?
Lordship, that is the second question we have, because that is already been passed by this honorable court. The matter is pending before Supreme Court. With regard to
How can
interest.
it be a question of law? There can't be a law that if the matter is pending with the Supreme Court, then the authority can't decide.
No,
it,
because Lordship,
until and
under
unless there
section,
is a stay.
our contention there under section 11B, in the case of exemption notification, because the notification doesn't provide for payment of interest. However, this honorable court, Lordship, with regard to
Can't be a question.
the
But this can't be a question of law. Until and unless if there is any stay.
but there is no stay.
There is
Lordship,
no stay, then even though if the matter is sub judice before the
Lordship,
Supreme
no,
Court, then also the authority
ma-
can very
in-
well.
in many cases, Lordship has disposed of the writ petition directing the department to pay the interest. That will be subject to the outcome of the writ.
That's another thing. But we can
And
do
what
that.
it-
But so far as regarding this question of law which you have suggested,
Manufacturing process, Lordship.
that only this.
That may be taken, that may be hard on that point. Number two may be Lordship, probably sufficient.
2 and 3 can be fused to make
Yes.
one question.
Yes, Lord.
Other question will be a perversity of the judgment.
Yes.
of the stat.
That is
These are the two questions only.
Only this question may be framed, Lord.
having heard the learned counsel for the applicant, we are of the view that the following substantial question of law is emerges in the present appeal. Number one, the only one here. Whether the process undertaken by the respondent fit into the description of manufacturing process of disposable syringe and amount to manufacture other than those specified in para 5 of the notification number 32/99 capital CE dated 8/7/1999 in bracket as amended. Admit, issue notice, returnable on so and so.
Actually, I filed in this case, praying for staying of the implement order passed by the CJP.
The prayer for interim application would be considered after service of notice upon the respondent.
Lordship.
Item 17.
Ordered.
Now, what happened? You have appeared in the examinations or what?
Well, that is not finished as yet. But in this matter, following this order, there are some writ petitions. In those writ petitions, this stay order was given.
The stay order was?
This stay order, which was given by the appellate court, that has been given in those petitions also. Except these two petitions for which we had to come for appeal.
We have already granted you the relief. So you have filed your application forms
Yes, my lord. Applications has been submitted, my lord, duly after the order.
and you have also appeared in the examination.
Yes, my lord, they are in the process, my lord. They are in the process of, my lord.
What remains in
finalizing.
these, now what remains in these petitions?
No, my lord, may I say that let this matter be listed after the
But it's
Apply 44.
We can make absolute disorder and.
May I suggest, my lord, let this matter be listed after the single judge dispose of the writ petition.
But you approached us for interim prayer for granting some interim relief, which we have already granted. Now you have appeared, your examination result is in the sealed cover. Some of the other petitioners who approached the single judge, same order was passed. Now what remains in this petition will make this interim order absolute.
Yes, my lord.
And
That can be done. That can be done.
okay. These are two appeals.
Two appeals, same order.
These intra-court appeals were referred by the petitioner, by the appellants, being agreed with the order dated
Absolute correct.
2/2/2024 passed by the learned single judge in the writ petitions, whereby while admitting whether while issuing notices, show cause notices to the respondents, learned single judge has refused to grant interim relief to the appellants. Full stop. This court, while this court on 9/2/2024 has already issued direction to the state to provisionally allow the appellants to apply in the recruitment process initiated by advertisement dated 26/12/2023. With the further direction that final result of the appellant shall not be declared without the leave of the court. It was also made clear that interim order is only in respect of the appellant and shall not create any precedent. With a further clarification that the pendency of the precedent, full stop, so and so, that's all. It cannot create any precedent. It is not in dispute that the principal controversy is remain pending before the learned single judge. However, as an interim, however, pursuant to the interim order passed by this court, the appellants have already appeared in the recruitment process, has already participated in the recruitment process, and the results have not been declared. And the results are being, the results are being withheld pursuant to the direction given by this court. Taking into consideration the above facts and circumstances of the case, we deem it appropriate to dispose of these writ appeals by making the interim order dated 9/2/2024 passed by the absolute.
Till disposal of the writ.
Absolute till disposal of the writ petitions filed by the appellants before the filed by the appellants and pending before the learned single judge.
Let the same order on the next one.
Order, right one is declared. Instead of. Sorry. Type of separate orders in both the courts, because the case number and order passed in single judge may be. Just me. Those will be the same, only check the case number.
Obliged, madam.
Item 19 to 21.
Last, the matter was listed on 10th of April. 60 was listed, writ appeal. There are 3 writ appeals were filed. But in other 2 cases,
it was not numbered because there is a application for delay. So notice was issued by this court. My learned friend is appearing
No,
for
no.
60.
Oh, yes.
60,
Yes.
60, he is appearing for 60. And there was a caveat which was filed and there was a delay which was condoned. But your lordship was not taking up because there are two matter common judgment, but two appeals, two appeals was not listed. But today also we checked my juniors at service. We have taken steps, but not, I think it's nothing has been reflected. I think we should take one more steps on the respondent minor.
In which appeals?
In this miss APS.
Item number 20 and 21.
21. I think one
Notice
step should be taken.
for condonation was issued on 16/2. And there is,
19, the delay has already been condoned and
Yes.
20 and 21, the services have not been complete.
Yes,
Service of
correct,
notice
correct,
of-
man, right.
लिखिए in writ appeal number 60/2024, delay has already been condoned and the respondents are represented through advocate. Should stop in writ appeal number 933/2024 and 938/2024. The service of notice upon the respondent has not been affected till date. Let notices.
Fresh steps. I think
let
we should
fresh
take it.
steps be.
Fresh notice will be.
Let the counsel for the appellant may take fresh steps for affecting service of notice upon the respondents in writ appeal number 933/2004.
appeal
936.
I think that's
My
not
lord,
writ appeal.
my lord, that
Writ
number,
appeal number.
no, my lord,
Is
that
a
is
filing-
a tender filing number.
Filing number.
It will be numbered after the conduct.
Registered number, okay, filing number.
These are filing
In
numbers.
writ appeal 933/2024 bracket में कर देना filing number.
Filing number.
And writ appeal number
And my lord
936
will kindly note down.
938/2024 filing number.
Yes, filing number in, there is two IA.
Notice
That
has to
is
go in the
in IA. 414 and 416. 414 and 416.
IA number 414 and 2024 and 416/2024. Steps be taken within a period of 10 days
Man,
on taking the steps. Registered AD and trustee both. ये 3 है फिर इसके अंदर, ये 940 भी तो है। So there are 3 IAs or this 940/2024 IAs.
My lord, this is there are in writ appeal 60, one IA is for condonation of delay and other one for stay. And the other two IAs for condonation of delay in respect of which lordship had earlier issued notice on
You
60.
gave the number of this delay condonation IAs to the court master, so
yes.
confused.
414 and something like that. Number-
Item 23.
May I please your lordship? Today's my rule is there here to submit, my lord. The last occasion I have submitted before lordship, the agriculture department had,
Yes, yes.
the issue is involved regarding lordship.
you are
Lordship,
good at
remember
it.
this.
You are
Then
good.
what happened? Then I have sent letter. Then after going through this letter, the other, I sent your lordship, they have made entire confusion of the judgment. Judgment was clear, paragraph 13, that as per Ramachari Devi case, she is entitled, daughter of this, he is entitled. Only that was direction was to that a department concerned, they will verify whether because unmarried or not, they will verify day after you can. But they have sent here, Dr. Bail, and the confusing to make to AG Milord. That is why I have sought clarification regarding that letter. That is why now
What confusion they have said?
confusion Milord Lordship go to, because they are confusing. If this much would have been okay, entitled you will, and whatever portion is
The
entitled.
authorities will decide the claim of the petitioner And in the claim of the petitioner.
Lordship, paragraph 4, your Lordship, may.
Released in respect of unmarried daughter as per law laid down. Full court on so and so and so. Therefore, it is not clear of this office, paragraph 4 of the letter communicated whether to a good office, you are therefore requested to enlighten us under the.
His pensionary benefit to given to all next of kin, so at least it's been given. That is why we are clearing, we are.
No, para number 4, what's it? His family pension may be given to the first wife as a trustee for the whole family as per the provisions of. So what's the confusion in this?
It is clear, the doubt is there, because
What is the
that apart portion which is entitled, the department has to see, send to us, to AG.
Plain and simple is that the lady has approached this court while saying that her unmarried daughter is entitled for pension
Yes,
and that first wife is not paying that pension.
yes, there is there.
The learned single judge, before the learned single judge, they said, no, we are ready to pay the pension to the unmarried daughter
Yes,
for share of pension or
Yes.
part of pension.
yes, yes, my lord.
The learned
Yes.
single judges held that
You verify?
determine there is unmarried daughter
And that is,
and she is entitled for
Yes.
a part of pension.
yes,
Then
that-
issue that order.
that part, that is, I'm also submitting, my lord, I'm going to lordship, that was the order. That was the order, it is already been decided, she is entitled. Only the documents should be verified, the department, they have to send to us, because AG only monitoring authority, they have to send the portion, what portion is entitled, what share is been already, that is they're supposed to give. But they are writing all letters here, my lord, make us confusion, that his other benefit will be to next of kin certificate also is given. He simply, it would have been, my lord, as per judgment, this one, that much clarification we want. Or lordship may clarify, we'll do it. Because this letter is not at all clear.
ये कह रहा है कि yes, ask them if there is no confusion with proceed. So if he is asking for a weekly, what is he saying? Give us the liberty, we'll do it for us.
Read that much clarification or lordship direction, because otherwise it is a confusing letter.
We direct you what?
Direct lordship, at least this much only, as we are praying
No,
for.
you just suggest us
I mean,
what direction you
My
are.
prayer, not as I cannot give suggestion,
No,
my
no.
submission is this,
Yes,
my lord.
yes, your prayer
Once
is
I have,
give
you know,
the direction to the accountant general. What
Yeah.
direction you are
Yes.
required to?
I have my submission before lordship today,
Yes.
as I have written later on this regarding clarification, let them give by 3 days or 2 days. Thereafter,
Okay.
today, after within
You
2 days,
are-
I'll pay.
You are in requirement of any clarification from them, or you're dependent upon their clarification. You yourself can decide the portion of pension.
No, that's correct, my lord.
So
But
then
this-
we are directing
that is-
you,
that is the
decide.
problem, my
We
problem
are
is here, my
directing
lord.
you, we are directing you.
My suggestion, yes, lordship direct definitely will follow.
Yes, we
But
are
this
directing
letter is
you.
confusing, this confusion should be clear.
Leave, ignore it,
Yes.
ignore it.
Then
We are
your
directing.
lordship,
Okay.
if ignoring this letter, we'll do it, my lord.
Yes.
Because otherwise we are monitoring
Learned
urgency, you
counsel,
cannot go
Mr.
beyond that.
Barua. Mr. C. Barua, learned counsel for the accountant general.
My lord, my lord.
Accountant general Assam has
That
submitted
is
that
response number 5, my lord,
some confusion was created
by the
on
department.
account of the letter dated 16/4/2024, Director of Agriculture Assam. And in relation to that, a clarification is sought from the said office by the Accountant General, full stop. Having taking into consideration the nature of directions given by the learned single judge in the impugned judgment, we deem it appropriate to direct the office of the Accountant General, Assam, to verify the claim of the rival parties and thereafter to decide the claim of the appellant, the claim of the respondent, as well as the appellant and their family members in accordance with family members as per the direction given by this court by the learned single judge in the impugned judgment within a period of
7 days?
within a period of 2 weeks from today and place the same before this court.
Only one observation, my lordship. If we want some clarification, let them give us.
Yeah.
During this, suppose any clarification required, because documents are with them. Any
Just
clarification
inform us-
required,
You just inform us on the next day that you are saying, you sought clarification and they have not given the
Yes,
clarification. We'll do that.
only it will observe. My obligation.
Now it's up to you, you decide it and
Yes, my lord. My lord.
Item 24.
Wait, please, your lordship. Lordship, this appeal is filed issuing the order dated first in WBC 1964 of 2022. Lordship, the appellant was working as a copyist.
yes,
Lordship, the appellant was working as a copyist in the office of the circle officer. His service was regularized in the year 1988.
but if that in that year, in the year 2005, there was no vacancy, then
Lordship, there were vacancies because, Lordship, we had preferred one contempt petition after the second writ petition, and in that contempt petition, Lordship, we had annexed certain documents which showed that there were vacancies.
having heard the learned concept of the petitioner appellant for quite some time, we deem it appropriate, we are of the opinion that matter requires consideration, admit, issue notice, returnable 10 weeks, AD Dasti.
That's okay.
They are accepting notice. All three respondents, yes. You are not accepting notice.
Respondent number 3.
Only 3.
Only
Mr. J. Endick for 1, Mr. B. Gogoi for 2, SC Finance, and Mr. Das for respondent number 3. Service
Service is therefore complete, less than details. Copy of the appeals we supplied to the respective concepts.
Much okay.
File the copy, supply the copy of the appeals to the respective concept of the respondents.
Yes, ma'am.
Yeah. File supply the copy.
I already supplied one.
You are
That I was
missing
finding only the
photos.
supply.
Supply the copy, another copy. Yes,
Oh, let's do. I'll do.
Item 25.
Meet with the lordship. My visit class registered. There, my lord, want to establish Ayurvedic college, medical college, dental college, nursing school of, and veterinary college. And the central and actual my lord, there, it does not give any provision for my lord no objection certificate from the state. But that has been inserted in a subordinate. I'll do that. Equity. And has been prepared on a delegated legislation manner. And they are inserted this provision, which goes against the spirit of 19(1)(g) and 21(a).
so you are basically aggrieved by the this
My lord.
condition of obtaining no objection certificate from the
objection
state government. So what's wrong in that?
My lord, that has been came before the Supreme Court also. In this, I have mentioned in my petition at page 25, my lord, the relevant portion, and these are the judgments. They said they did not.
State
34.
Act cannot lay down standards and requirement higher than those prescribed by the Central Act. Okay, that's right. But so far as regarding no objection certificate,
You kindly go through paragraph 34, 35. I want to 9. 34, 35.
Lordship, there may be some rationale behind this, Lordship. Let the All India Council of Technical Litigation, they have
find any
authority.
counter? Have you
Lordship,
find any counter?
no, to this is the first day, Lordship.
The first day. Notice,
I'll be for 4 and 5 only, Lordship.
yeah,
I'm for 2 months,
1 and 2.
only 2 months.
Should notice, Mr. So-and-so put in appearance on behalf of respondent number 4 and 5. Mrs. So-and-so for respondent number 2, let notices be issued to the remaining respondents returnable on so-and-so, so-and-so. 80 Dusty requisites 1 week.
Problem.
Item 29.
Lordship, my senior is on late in another court. Item may be taken up at 2 p.m. if possible.
Can't say 2 p.m. whether it have time or not. If your senior is busy, let them be adjourned.
Next week. Next week.
Next week.
Would like
Item 30.
May it please your Lordship. My Lord, this matter relates to regularization of contingency appointment, my Lord. In this
34 years.
regard, my Lord, the
34 years they worked with the government on 34 years.
Lordship, that is why submission was made by the Advocate General that a policy is coming up to
What
usage.
policy?
A policy, the government is coming up
No,
with
no,
a
now they
policy.
have already been retired. The learned single judge simply said then grant retired benefits and nothing else. This is what the direction is.
There are a lot of other cases also, my Lord. And therefore, the government is coming up with a policy to
The single
usage
judge
the
judgment
plate.
directed the state to provide pensionary benefit regularized India. That's the only thing. 34 years they worked with the.
If you're some more time,
Judgment which can happen in next week.
I am therefore, my Lord, instructed to take some more time. To give the government to
Matters
come
if
up
the
with that.
Advocate General is required to, whether the Advocate General is required to appear in
Lord.
these petty matters.
Lordship. He will be appearing, my Lord, but
The request of land council is none. Adjourn.
obliged.
Item 32.
Please, Lordships. Whereas on the last occasion, Lordships had directed the respondents to come up with updated instructions with regard to the anti-quackery units that have been directed to form in each of the districts. Anti-quackery units. This is a PIL concerning quacks within the state also.
Lordships, Home Department has filed report from 26 districts, Lordship. Some more districts yet to receive instruction, Lordship. Respondent number 11 has filed one affidavit, Lordship.
Okay.
Some
Council appearing for the respondent. Which department you are?
I am appearing for Home
I'm for the
Department.
Health Department.
What section you are also supposed to
My report
clarify?
says about 13 districts, my lord. Others are evaded, my lord. Only 13 districts have got the report. For rest, my lord, is evaded. Otherwise, my lord, quackery unit has been already, my lord, established in all the districts. But how they have executed, my lord, that report is evaded.
That we
May I make one
specifically
more
asked?
submission?
Yes, my lord. I have communicated already, my lord.
No, what do you mean by communicated? That is your in between you and
understand.
the department.
No, I
How
convey-
this court is dependent upon that. We have communicated, so you are shook of
No,
your
I-
responsibility and will.
No, my lord, 13 reports.
He
we
has
have
said
got.
like
I
that,
prefer-
oh, once he has communicated, now his department will come and then.
No, no, I'm on the behalf of the department, I'm praying for some further time. We have got 13 reports from 13 districts.
Don't make such type of submission. We have already communicated. So what to do with us? You have communicated, now it's the responsibility of yours to
Yes.
get the,
That is evident.
whatever the. Okay, then in council appearing for the health department as well as the council for the, as well as the, home department. Waste some more time to furnish the reports regarding the measures taken by the health department as well as the home department against the quacks operating in the state of Assam. And to apprise that the directions issued by the director of the health services in May 2023 has been complied with or not. Less than 2 weeks.
May I make one more submission, Lord? Because they are forming the anti-quackery units, that is right, that is okay. But if we want to prevent the quacks from getting into the system once again, so there needs to be a comprehensive mechanism through the state so that.
What mechanism you suggest us? How can a person, if opening a shop that I am a doctor and doing something, how can you prevent
At
that?
least with regard to the hospitals, Lord,
You
if
can
there is.
prohibit them after ascertaining or locating them. What is the?
In order to prevent them from coming back, because there are instances where the FIRs have been lodged and they have again started practicing. So state needs to come up with.
Suppose a person has opened his shop or whatever the clinic in Jorat district. And now he, after whatever his arrest or whatever action taken against him, he opened a shop in Kokrajhar. How can you stop them?
That's-
What mechanism you are suggesting will consider? Yes.
Keep the blessings.
Item 34. May I please, Your Lordships? Your Lordships, in this matter, the pleadings have been completed, so Your Lordships may kindly be pleased to release the matter for hearing. Fix the matter for hearing.
Has it been admitted? The bill has been admitted.
No, Your Lordship, I pray for admitting it and listing it for hearing.
What's the matter? What?
The matter pertains to pay, the appellant is agreed because his pay was not protected. When his institute where he is working has been transformed from state government to central government, his pay was not protected. And that is his grievance.
How the learned single judge has dealt with it?
Learned single judge, Your Lordship may kindly come to page 93.
What?
The learned single judge said that till the date when he was taken by a central government, till then, that date he will get the state government pay, the revised pay, the 6th Assam Pay Commission pay. But after that, his pay is reduced. His pay, as per the 6th Central Pay Commission, his pay gets reduced. His grade pay is not protected. His basic pay and grade pay are reduced. Lordship, may I explain?
And where is the provision of pay protection?
Lordship,
Which is the provision?
Fundamental.
Lordship, whenever
See 2 years. No, pay protection is not prescribed, sorry, it's prescribed under the FRS, fundamental. It is fundamental to the applicable in all government entities.
बारीकी से देख नहीं बताया। Hearing.
Then it concept of the parties have submitted that pleadings are complete and matter requires final hearing. Hence, admit no need to issue notice as parties are represented. List for hearing in reports.
Oblige, your lordship.
Oblige.
Item 35.
Please, your lordship, lordship here, AG, your lordship, he's on his leg right now in the Supreme Court. So lordship, I pray that the matter may be passed over for the time being, your lordship.
Who is not available? Who is not available?
Advocate General Nagaland.
Advocate General
Yes.
Nagaland.
Right now, he's on his leg in the Supreme Court, your lordship.
Advocate General of which state?
Nagaland, Nagaland.
Yes, what do you want to say?
So to pass over for the matter for the time being, your lordship, he will come right after his matter is over.
May I please, your lordship?
The last time we have made it clear that in the absence of the Advocate General, we have to will hear this matter.
Yes, yes, your lordship.
So
So
now why you are making this submission that the Advocate General is not available?
no, your lordship, then in that case, your lordship, I pray that the petitioner can continue so that after his matter,
We are not going to hear in piecemeal.
lordship, he will join, your lordship. But the thing is
When?
that right now he is
When
on
he
his
will
leg.
join?
After his matter is over. So your lordship, his matter may be over after some few minutes. In that case, the petitioner may continue, your lordship.
Ask the Advocate General to remain present at 2.
Lordship, lordship.
We'll take this matter at 2.
Much.
Your lordship is not taking up the matter?
At 2, after lunch.
Item 37.
Your lordship was pleased to hear a similar matter yesterday, your lordship. May I pray that both the matters may come up together, your lordship.
Yesterday, what happened in that?
Lordship, item number 1, your lordship, yesterday, 1591 of 2024, your lordship.
What happened in that?
Lordship had fixed date for hearing in the month of June, your lordship, the first week of June.
Matter was admitted and fixed for hearing on. Same issue, my lord.
And counsel for the appellant has submitted that NCET that
Yes.
Mr. Chaudhary appeared in that.
Lordship.
The identical writ petition number so and so, that the writ petition involving the identical writ petition involving identical question has already been admitted and listed for the hearing and listed for the hearing. Admit list on so and so along with number.
WBC 1591.
Supply the number.
159.
Obliged.
Supplementary list for order, item 52.
Respondents have appeared.
Stay declared.
This matter, my lords, there is a notice issued against a dead person. That is a
Which?
page.
Against?
Against a dead person. That notice
Not the-
is at page 133.
So,
Because I had requested my learned friend to convey an offer from the petitioners that they are willing to clear the outstanding overdues of around 1 crore by next 15 days.
Sir, some judgment I placed in the
This is Gawai Satyavati Kannan.
some judgment of 10th of April 2023. I asked the person to place it on record and he has placed it before he come here. Judgment there. In fact, I asked them to place it on record or उन्होंने लगाया था, come here. It's 10th of February 2024. Justice Gawai, Justice Mehta and Nagaland. There is a judgment on third basic.
All chambers it was circulated.
That has been circulated. Mr. Have you gone through the latest judgment of 10th of April of the Supreme Court?
No, not. My humble submission is.
Whatever humble submission in the securitization matter,
Lordship.
the Supreme Court has, what the Supreme Court has observed.
Right. No, that may be, but the fact remains that this notice, as on date, was issued to a dead
Raise
person.
all your objections before the authority concerned, not here before this court.
No, my lords, there is one relief, my lord, which that tribunal cannot give me, my lords.
What?
That is the relief at page 52, my lord.
What?
That is, my lord, my request for unblocking my current account. What has happened in this case?
That very well can, in
they
all
cannot-
ancillary matters,
No, 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 my lord.
the tribunal can grant this
No,
relief.
my lords, I must humbly submit, my lord, that the tribunal has no authority, my lords, beyond what is there in section 17, my lords. Unblocking an account cannot be, my lord. This is basically a writ
This
matter.
is the process of, you can very well ask them, okay, sir, this, whatever the notice under section 13(2) is illegal and therefore whatever the consequential.
No, my lord,
order,
because
that can be done.
13.2 cannot be decided by the tribunal. The tribunal can only go after 13.4, my lord. That is the crux of the matter, my lord.
Then certainly, if the no proceedings at the stage of 13(2) and there are judgment of the various courts and the Supreme Court wherein they have said okay, at 13(2) you are not required to even heard at the stage of 13(2).
That is why, my lord, my relief is not before the tribunal. My relief is here, my lord, before the writ court.
Go through that judgment and come argue at 2.
Sure.
10th of only 10th of April 2023 and otherwise we'll pass an order. We'll get an order and supply it to you.
Item 53.
May please your lordship. One of this matter relates to settlement of fishery. Well, there was a litigation earlier. And where the appellant was also a petitioner, where this honorable court directed that fresh settlement should be issued, fresh NIT should be issued. So, my lord, that order was passed on, my lord. Thereafter, my lord, there was an appeal.
Where is that order?
That order, your lordship will find, my lord, in your order, page 61.
60.
Page 61 was the order of the honorable single bench. And the petitioner appellant before your lordship was also a party there.
Where is the order of the division bench?
My lord, the division bench order is at, my lord, page 72.
70?
72. The division bench, my lord, did not interfere, your lordships. And my lord, therefore, my lord, that direction became final. And the, my lord, respondent authorities were to issue a fresh NIT.
So we have dismissed the petition, but single judge in so and so allowed the appellant to send the fishery in day to day. Okay. And
Then, my lord, what happened? My lord.
Things over the impugn order that it was within allowed. Yes.
Then, my lord, the authorities were to issue fresh NIT, but then in the meantime, because of certain factors, including, my lord, the fact that, my lord, model code of conduct also came in. And it will take some time for regular settlement. My lord, the fishery was settled on day-to-day basis for a limited period of time till the, my lord, the final regular tender process is completed. And, my lord, there, my lord, three parties, they filed their application, including the appellant, and the appellant's offer was the highest. So on the day-to-day basis, my lord, it was given to the
Fine.
my lord. Then, my lord, that was challenged before the single judge on the ground that, my lord, the other party, my lord, they had offered, my lord, without specifying any amount, they said, I will pay higher daily rate. Now, my lord, that was the issue. Whether, my lord, the issue would have been got, my lord, our the allotment settlement was day-to-day settlement was right or not, my lord, that was the issue. But the honorable single judge, if your lordship comes to the impugned order, which starts at page 123, there, my lord, two aspects. The honorable single judge has discussed the earlier, my lord, writ petition and writ appeal. Then your lordship will kindly come to paragraph page 128.
This tender process, which is withheld on account of this model code of conduct or whatever reason. Now the department is saying that they are going to settle complete the procedure by 10th of May 2024.
Now, my lord, the honorable single judge, in fact, my lord, although that was not an issue, honorable single judge has gone to the, my lord, election code of conduct, but wrong, my lord, notification and held that, my lord, there is no bar in issuing a notification, issuing a tender during the, my lord, model code of conduct.
Tender has already been floated.
Tender has been floated, my lord. There is contrary to the, my lord, election commission guidelines, my lord, I have annexed in the writ appeal.
But you are not challenged that.
No, I have not challenged, my lord. Because of this order only, my lord, the authorities have now issued a fresh NIT. In addition to that, my lord, all the, my lord, settlements which were given on day-to-day basis all over Assam, my lord, those have been, my lord, directed to be, my lord, the continued only till 10th of May.
So then the aggrieved person will come.
No, my lord, my submission is this, my lord.
Yeah, but Mr. You are for the.
I am for the my lord deputy commissioner, my lord. So far, my lord, fishery department is concerned, my lord. They are.
So they have already issued the NIT.
Yes, yes. NIT is annexed in this petition, my lord.
And what happened in that NIT?
My lord, the process is going. NIT is at page 139.
NIT has been issued.
Yes, my lord.
And bids have been received.
Yes, my lord.
Now, by what time you are going to finalize the NIT?
It is, my lord, the date of opening is, my lord, fixed at 21/5/24.
21/5/24. May.
21 of this month,
May 2024.
my lord.
So let him continue up to the this process is complete.
My lord, continuation is, my lord, fine, but I'm on to other aspects, my lord. Personally, my lord, during my lord, the model code of conduct, my lord, this could not have been.
We are not going to entertain all this. This is not at all the subject matter. That petition is still pending.
That petition is pending, my
That
lord.
petition, you have not, basically, you have not filed any petition.
My lord, in fact, these two orders.
The other persons have filed a petition, the respondents have filed a petition that your continuation on daily basis is wrong.
Right.
That is,
My
that was under challenge.
My lord.
Whether any tender proceedings can be issued in between the model code of conduct or whatever it may be, that may be London single judge observed, but This was not the subject matter before the learned
No,
single.
my lord, it was not.
If you are aggrieved that in between during the model code of conduct, if they have issued a tender process, that is a separate cause of action. You will file a writ
No,
petition. You
but
can't
then, my lord,
agitate here
the
in this
tender has
appeal.
been, a tender has been issued only pursuant to the direction of this honorable, of the honorable single judge.
Whatever it may be.
And also, my lord, all the fisheries,
Sir,
that
if you are aggrieved by the fresh tender process, you may challenge it by way of separate proceedings. Your grievance up to this stage, what we understand is that up to 10th of May, the single judge is confined. We can extend it up to the
final settlement.
settlement of this fishery pursuant to the NIT issued thereafter. That's all.
My lord,
May I lordship? Lordship, pursuant to that order, lordship, we have issued a general order also for to all the district commissioners.
What?
But that,
That can't continue the.
no, I'm just running, lordship.
Oh, that's right, but you have issued a order that no fishery can continue on daily.
Daily basis after through all district, I have.
After 10th of May.
10th of May, we have issued all the district
all
commissioners.
over Assam, my lord.
First position.
On the strength of this,
They'll come by you.
My lord, that is why, my lord,
All the district
that is why my humble submission, my lord, that my lord learned friend, my lord, the writ petitioner has no
At
cause
two,
to
at
challenge
two.
this.
At two.
Lordship. I know. To the order passed by the learned single judge, lordship. We have issued a general order, which is in page number 137, lord. May I read, lordship?
Yes.
It appears, this is the order, it appears from the above that the system of running 60% government fisheries on daily basis in the interim till next regular settlement has been reviewed. This is so and so. This part amended with Convention Rule 12 of Assam Fishery Rules. Such arrangement often leads to litigation as rival parties also stake claim on such arrangements. And as a result, the matter of regular settlement get delayed till such matters are decided by the Honorable Court. The Honorable Court is of the view that temporary arrangement not even backed by existing rule results in loss of revenue to government exchequer as well as precious time of the Honorable Court. Under circumstances, government, after careful consideration of all materials in hand, including observation direction of Honorable Court in the instant writ petition, has decided that all such daily basis temporary running of 60% government fisheries based on lump sum revenue will be operational to 10/5/2024 only. Consequently, concerned district commissioner will take over position of such fisheries on 11/5/24 and keep it as cast till regular settlement through tender system. In the meantime, so that all we are giving this order so that transparency are maintained also. In the meantime, all concerned districts will take steps for regular settlement of such 60% government fisheries with issue NIT with annual lease value assessed under Rule 48 and process the proposal accordingly as per procedure. However, formal settlement under such fisheries with due approval of Government of Assam Fishery Department as empowered under Rule 12 of Assam Fishery Rules will be issued with prior permission approval of competent authority. It is further clarified that there will be no daily basis running of any 60% category of government fishery after 11/5/2024. Consequently, no government fishery of 60% category can be settled without tender except as per Rule 12 of Assam Fishery Rules 1953. It is further ordered that in case of existing 60% category of government fisheries, which are already settled through tender process and is on the verge of completing 7 years tenure, fresh tender to be initiated 6 months prior to completion of lease period of such fisheries and to complete the settlement process well ahead of expiry of existing lease period. Necessary executive instruction to this effect will be issued regarding this issued to the district commissioner separately for strict compliance so that there is no loss of government revenue for delay in settling 60% category government fisheries. This is that's it.
Where is that fresh NIT?
Lordship, here actually, this was actually initially, Lordship, what had happened, we took, actually this process was earlier misinterpreted by the government officials, Lordship, by the officials, while selecting the daily basis, Lordship, they used to take some representation, not participation of all the bidders, not through any tender process. He was selected, not nothing as a tender process. Lordship, some representation were collected from some his lessees, Lordship, and after that they were selected, Lordship, because against the rules, Lordship, which was wrongly misinterpreted, maybe, Lordship, in our earlier phase, Lordship. So it was being clarified now, Lordship. So
We are
now
not
we will
going to, we are not going to interfere with the rest order passed by the state. But we are simply saying that since in this matter, the NIT has already been issued.
Lordship.
And where is that NIT?
Page 139,
Page?
139.
And it is going to be settled on.
After it will be, we will settle it, Lordship, after completion of the model code of conduct.
Why?
Sorry, Lordship, after 10th of May, after completion of election, Lordship.
Completion of election in Assam, the
Seventh. That is, we will.
On 7th of May.
Yes, Lordship.
So you do it by 21st, if you the last date or the date which you have mentioned for this accepting the financial bid. Till then, you may continue.
Lordship, there is a problem, Lordship. This NIT is issued by Deputy Commissioner, Lordship. Lordship, they cannot settle it, but they have to forward to us, Lordship. So it will take some time, Lordship. It will take.
Circumstances, Lordship, my Lord, Lordship may kindly see paragraph 7 of the judgment, my Lord, of the learned single, page 135.
Yes.
Paragraph 17. If for any compelling reason, daily settlement has to be extended beyond 10/5/2024, the process of putting the tender on daily basis shall be notified in the Dhubri district so as to enable all the fishery cooperative societies in the state area to participate in the process.
But that's
My Lord, because my Lord,
for a 10 or 20 days, what?
my Lord, 10 or 20 days is not, my Lord. What has happened in, my Lord, settlement issues, my Lord? Why, my Lord, Lanet, my Lord, Tingujas has issued these guidelines. By any means, they try
There
to.
are cases of arbitrariness in between. The officers are entering into the agreements with the.
While we are initiating this process as a transparent way, Lordship, all the district commissioner has been issued for taking possession after 11th of May, Lordship. So this process was going on since years, Lordship. Lordship knows this, Lordship.
Take my Lord, if my
This is only to get it transparent, Lordship. It may be similar to that one, Lordship, in the corporation one, direct settlement one, Lordship. This was not adhering any rules, this daily settlement rules, Lordship. So interfering with that, all the districts, Lordship, district commissioner, it will again.
There will be a floodgate of litigation, my Lord. Those who are, my Lord, running the fisheries on daily basis, well, they will again come, my Lord.
Anyway, Lordship, it's Lord.
That is why, my Lord, for.
Mr. Chaudhary, the reputation of these fishery societies is not very good. That's what they are saying. They get an interim order, cling on to it, and then get some order, some petition file again.
It is the other way around. Another party was given for a period of 7 years. Then it was extended, it kept on running for 4 years.
That's what they are saying. There is a modus operandi here.
Yes.
Modus operandi.
And you get an order from the court and then complicate things to such extent. We have thanks to some very competent lawyers helping them out, that it takes years together for any judge to even reach to the bottom. So by that time, 3-year settlement continues for 15 years. And then also something is done at every stage. There is a stay order. At every stage, somebody will challenge every stage.
True.
That is what there is nothing to do with your client in particular. It's a general.
But then, my lord,
So we are in fact thinking that whether there should be a complete moratorium of any interim order by any court in any fishery matter, regardless of whatever be the outcome. Fishery matters, tender settlement, every fishery, every tender is put to challenge. Can you think of a tender which is not put to challenge and not by one party? Several parties at several stages.
Because, my lord,
This is a problem. It's nothing particular about your client, or we are not saying anything on your client.
And why this order is dated 9/4/2024?
my lord.
And now you have challenged immediately. Why you are not challenged since now your term is going to over?
No, 9.
You have approached this court.
No, my lord, this order has been passed. These two orders are, my lord, 12/4. NIT has been issued on 12/4.
9/4/2024 learned single judge order.
Yes, my lord.
And now
At that
you
point-
have, when your time is going to, this time for the 10th of November, May is approaching.
Yes.
You have immediately came here. No? This is,
No, my lord, in fact,
you be happy with your daily settlement up to 10th of May. That's all.
No,
We
my
are
lord,
not
my
going to
submission is
interfere
this,
in
my
the-
lord. These two orders, this NIT and the, my lord, that notification, those have been issued pursuant to the, my lord, my lord, according to them,
You may challenge it.
it has been, my lord, pursuant to that, my lord, unless I challenge that order, my lord, I cannot challenge those orders.
Whatever it may be, that then we are going to dismiss your challenge. To
No, my
this
lord, my submission is this, my lord.
Yes.
These two orders that have been passed, one is the NIT. That is, my lord, contrary to the election code of conduct.
That you raise in appropriate proceedings, we are not going to consider.
Well, very well, my lord, but they say, my lord, this is pursuant to the order of the honorable single judge, which is not.
That the
Unless your lordship, my
the
lord, makes.
appropriate forum will check out that whether it is in pursuit of the court's order or not.
My lord, and the guidelines that has been issued, my lord, that they say, my lord, pursuant to the direction of this honorable court, there is no direction as such. Unless, my lord, your lordship interferes with that order or makes some observation, my lord, if your lordship kindly comes to
Well, here the other parties are also there. We'll hear them.
12/4/2024.
Just notice that.
12/4/24, my lord, this my lord, pursuant to High Court order
So-and-so,
is not.
you are appealing for
I am for Fishery Department, P. Sharma.
respondent.
3, 4 and 5.
Mr. So-and-so put in appearance on behalf of the respondent number 3, 4 and 5. You are appealing for
1 and 2, Lordship.
the so-and-so put in appearance on behalf of the respondent number 1 and 2. Let notice be issued to the respondent number 6. Returnable.
We can take Dusty, my lord.
Just the returnable on
Vice Mayor.
22nd of May. Just the
My lord, unless your lordship makes some observation, we cannot challenge those two orders before the Supreme Judge.
don't challenge it. This writ petition is still pending.
Highly obliged.
This appeal is pending. You come and.
Item 52.
Just a minute. There's a Nadi ka do kinare of interesting. Settlement.
Maybe. Look, we have seen, we have gone through, the only question is pages one, just 2 pages, 133 and 155. The person has died. my lord.
In the light of this judgment, latest judgment, whether we can entertain any such petition.
Because, my lord, if I may humbly submit, my lord, the person has died, the order is a nullity, my lord.
Whatever it raise, wherever you can raise this. These after these harsh observations, please.
No,
Don't pursue.
I'm not asking, my lord, for anything,
No,
any
don't
liberty, my lord,
pursue.
but page 133 and 145, 155, my lord, lordship will kindly have a look. Just 2 pages, my lord. So the order is a nullity, my lord.
You raise these issues. How are you presuming that the tribunal will be able to deal with it or not? You raise these issues.
Lordship will grant that liberty, my lord, to raise all
Because
issues.
Mr. Ganguly, the Supreme Court has clarified,
Lordship,
this DRT Act is not for granting remedy. It is for recovery.
that is correct.
That is the legislative intent. The Supreme Court has upheld the act
Yes,
in Mudra courts.
Lordship.
And therefore, if you take loan, this is the outcome.
No difficulty, my lord. Only the
That's the
liberty
way
may be granted, my lord, to raise all
That's
issues
the
at the
way.
appropriate
You have to
stage.
be
my lord.
paid.
After attempting to argue the matter for quite some time, on a concept of petitioner submitted that he may be allowed to withdraw the petition with liberty to raise all available grounds before the remedy, before the appropriate forum under the Securitization Act, dismissed with liberty as prayed for.
Public.
Your lordship, interim order passed.
Dismiss अगर writ हो गई है, then still the interim order will be will remain in operation.
Item 35.
Oh, you were virtually there now. During lunchtime, you came down.
No, because there was some audio problem in my chamber. So I thought it would be better that I come personally. I wanted to come personally, but in the morning I was not feeling well. So I thought I'll do it from there.
What's the controversy about?
My lord, here we are challenging, my lord, the constitutional validity of a service rule which has a little longer name. Nagaland Land Resource Development Department Service Rules 2008. I'll call it 2008 service rule. More particularly, Schedule 2. Now, my lord, this is not the first time. There is a second round of litigation, and therefore I will take your lordships through the background, which will be important, my lord, on the conduct of the government as well as on the merit of the case. The stand, vis-a-vis the stand that they have taken now in their affidavit in opposition. My lord, the department, Land Resource Development Department, is mainly concerned with the development of integrated wasteland. Because this was, if your lordship remembers, during the Green Revolution, which was adopted by Madam Gandhi in 1973-74, this integrated wasteland development program was undertaken. And since then, my lord, this is on. Thereafter, the departments were made. Earlier, it was under the board. Then the departments were made. And the state of Nagaland also has, my lord, created a department. It's known as Wasteland Development Department on 14/9/1993. I'll just take your lordship through the order at page 38. Page 38. In the interest of public service, the governor of Nagaland is pleased to create the Department of Wasteland Development under the government of Nagaland with a separate head of account, etc., etc. So this was the date on which 14 September 1993, the department was created. The name was subsequently, the department was renamed as Land Resource Development Department. The petitioners before your lordship, petitioner number 1 to 3, they are at present serving as the district project officer, a DPO. And petitioner number 4 is the assistant project officer, APO. Before this service rule, which was made in 2008, there were no discrimination. I'll say there was no division among because the personals were drawn from different disciplines, my lord. It's a multidiscipline professionals who were drawn in because the name itself suggests, my lord, integrated. So therefore, there are graduates, my lord, agriculture, horticulture, forestry, then engineering. Then there are postgraduate in botany, social science, etc. That I'll take your lordships. So before this present rule, there was no creation of wings. This department, this service rule created 2 wings. They call it one technical wing and the other was extension wing. Now the personals, the officers of the extension group, they were, my lord, discriminated in the matter of promotion vis-a-vis the personals of the officers of the technical wing. And therefore agreed, my lord, they filed these petitioner 1 to 3, they filed a writ petition before the Kohima bench, my lord. And before we filed, the extension wing filed, there was a pending petition, writ petition, which was filed by the technical wing. It was filed by the individual personnel, so for the convenience sake, I'm referring it. So the technical wing filed a writ petition before the Kohima bench, my lord. There they prayed that seniority list should be separately issued for the technical wing. So these 2 writ petitions were pending, one filed by us in 2020 and the other filed by the technical wing in 1990. But the respondent number 4 here, the director, he took, my lord, initiative for an out-of-court settlement. And we were given we means extension, the petitioners were given to understand that government has already taken steps way back in 2015 for amending the rules, 2008 rules, so that this discrimination can be done away with. This was the understanding that was given to us. We agreed. And thereafter, my lord, there was a letter written, because they are now denying, my lord, the agreement, existence of agreement. They are saying.
What happened to those writ petitions?
Those writ petitions, my lord, we withdrew it with the liberty to file. I'll take your lordship through the order. Now, the agreement, if your lordship permit me, I'll take your lordship first to the agreement, page 100, my lord. Page 100 of the Republic. On this, the 2nd September 2020, Department of Land Resource for the first part, hereinafter referred to as first party, the officers of the technical wing cadre on the second part, hereinafter referred as second part, and the officers of the extension wing cadre on the third part, hereinafter referred as third party, have mutually agreed to come to an understanding to solve the impending issues of seniority and promotion, dispute and litigations between second party and the third party. Whereas all the parties deliberated at length and considered the issue of seniority, dispute and promotional right to accommodate the right and privilege of the second part and the third part in the matter of seniority and promotion. And whereas the Service Rules Amendment Committee was set up and the rule amendment is at final stage, except to be officially tabled and approved. Now, whereas the department on the first part has minutely examined the existing service rules and decided to amend the rules to give equal protection to all the officers in the department and the second part and the third part. And whereas Service Rule Amendment Committee has worked out the modalities for the officers of the second part to be HOD of the department, and the provision for promotion of third part shall be till the post of additional director, post cadre review. And whereas department on the first part has examined the present availability of posts and felt utmost necessity for the cadre review to effectively amend the service rules that will benefit parties of both the wings, cadre of the second and the third part. And whereas pending cadre review and the service amendment, all the parties agreed to abide by the terms and conditions laid down in these agreements. Then there are agreements. Only clause 3 will be important, that I'll take your lordships through the next page 101. Because from here I will show, my lord, what steps were taken after filing, after this agreement. Third says, my lord, on the approval of the government of the card on the approval of the government of the cadre review, the service rule shall be amended in tune and in harmony with the tripartite agreement. And then other not important. So this was, my lord, the agreement, wherein it was given that the
Agreement is dated?
Agreement is dated 2nd of September 2020.
Yeah.
This was during pendency. Now, thereafter, my lord, kindly come to page 103. 103 is respondent number 2, my lord. He is commissioner and secretary to the department. He writes a letter to director. I'm just showing this so that they were aware of everything. They cannot say that they were not aware of these. Director, Department of Land Resource, Nagaland. Submission of tripartite agreement to withdraw the pending petition before the Honorable High Court. On the subject indicated above, I am to acknowledge the receipt of your letter dated so-and-so. Since the petitioner of the writ petition number 40 of 2020, this is our writ petition, and WPC 211/209, this is the technical wing, have now come to an agreement to withdraw the petition. You are requested to instruct the petitioners of the second and the third parties to pray for withdrawal of petition from the Honorable Court. Then the next page, if my lord will come. This is a letter which is sent to the Additional Advocate General, Senior Additional Advocate General, Nagaland. With reference to letter number so-and-so, I have the honor to state that the government has acknowledged the departmental tripartite agreement, your lordship kindly mark it, on 2nd September 2020. In this connection, I am to apprise you about the agreement to take appropriate steps for withdrawal of both the pending petitions, so-and-so, so-and-so. Then the tripartite agreement dated 2/9/2020 was enclosed along with this letter. Now, following this letter, my lord, this was withdrawn, and the order of the High Court I'll place where these agreements have been mentioned, agreement was mentioned. My lord will kindly come to page 105. This is the first one by the technical group. The relevant is at page 106 that I'm placing below. Then senior counsel for the petitioner so-and-so are present. The senior counsel for the petitioner submits that there has been a tripartite agreement between the party to settle the dispute outside the court, which has been filed before the registry. He therefore prays that the matter may be allowed to be withdrawn with liberty to file a fresh extra advice. Mr. So-and-so has no objection to the said prayer. Prayer is allowed. With submission of the party, the writ petition is allowed to be withdrawn with liberty to file afresh if so advised, stands disposed of. Then next is, my lord, the order in respect of the writ petition filed by the petitioners from the extension branch. The relevant is page 112. 108, 108, I'm sorry. 108. Yeah, 108 means. Relevant will be page 112, my lord. Mr. Sir, learned counsel appearing for the petitioner submits that an agreement has been reached between the parties outside the court. Therefore, she may be allowed to withdraw the petition with liberty to file fresh if so advised. And then it was accordingly allowed.
So basically, your argument is that once the government has entered into an agreement and now till date, they have not amended the.
No, my lord, it has gone much beyond that. The rules were amended.
Rules were amended.
But it has been the last information that we have that the director was not happy because there were less posts sanctioned. So he says, keep it in abeyance. And after that, we don't know what has happened.
The rule has been amended as per your desire.
My lord, as a draft amendment, I have annexed. It has not been finalized. It's at the draft stage. Now, my lord,
It means it has not been passed by the legislature till date.
My lord,
It has not been produced, presented before the legislature to be.
no, my lord, it was sent to the government. It will be a rule under 309. The governor will make that.
309, yeah.
And the director has sent it to the secretary. Just lying like that because after the director wrote a letter. I'll place all those, my lord.
What is their stand in the this writ petition? The counter
They are disowning the agreement, basically.
agreement.
The agreement they are disowning after all this. There are more to come, my lord. Let me show, my lord, what has happened. Now, after this, my lord, after this,
No, what they are saying? No such agreement was entered into, or
they are saying, my lord, first thing, that this agreement is against the rules. It is for the amendment of the rules, but they say it is against the rule. Then the second point about the rules which they have said is that the government was not a party.
Government was not a party.
Not a party. The director had signed. So that they're saying that. But I'll show you what step the government has taken. What step the government has taken that I'll show to you lot. And ultimately, of course, I'll go to the merit also. I have to go on merit and show that the rules are discriminatory.
This seems to a matter requires full hearing.
A full hearing, my lord. At least 2 days your lordship will give me.
Then we'll admit the matter and then we'll fix it for the hearing.
My lord.
May I please your lordship?
And another thing,
Yes.
May I please your lordship?
Yes.
My lord, since your lordship has taken a view that it has required a full hearing, and I personally view also that through VC it will be an issue.
So that is for you people to consider. This is not for us. We can't say you don't appear with by this VC mode. That
But
is for you people to consider. If you appear in person or in VC, we are supposed to hear you.
My lord, in that case, can we have one particular date of all the convenience? Because for me, the interim order is there against me, number one. Number two, I believe Honorable AG will also accept this fact because there are the department has got some posts which are vacant now because of the interim order.
You agree on a convenient date? Certainly we'll hear on that date.
Mr. Borgoy, you just raised a question about VC, but you're yourself on VC. What is the reason? Why are you
Pardon,
on
my
VC?
lord?
You just said VC is not convenient and then you are yourself on VC. What is the reason?
My lord, I had to have appearing in some other matter. That's why I was constrained to appear through VC because we agreed to take up this matter on today. And since your lordships have find that after hearing
You are
about my
not in
senior.
Guwahati. You are not in Guwahati, is it?
No, my lord.
Yes,
any date, my lord.
you please consult yourself and any.
I'm agreeable to any date, but let it be in the last week
Mr. Advocate General.
week starting from 28th of May.
Yes, Mr. Advocate General.
My lord, maybe either sometime in June or July, which is
Okay,
convene.
June, which date you are offering?
Can it be on 1st of June, sir?
No, not first.
That's a Saturday. We don't come to court on
Oh,
that.
sorry. Okay.
Let it be after 10th June, subject to your lordship's kind convenience.
Subject to you, please convey your date, you please.
We will inform the court accordingly, my lord. My
Okay,
lawyer.
you consult yourself in
Please.
between yourself and then inform the date.
Only to mention that whatever argument has taken place so far,
In
I've not-
why this petition, a challenge is laid to the validity of the Land Resources Development Department Service Rules in 2008.
Not working.
Readings are complete after hearing the counsel for the parties. We deem it appropriate to admit this petition. Parties are represented to their counsel, so no formal need to issue notices, no formal notices are required to be issued with the consent of the parties. Place this matter for hearing on.
Week is starting from 11th, my lord, 10th, but 11th, your lordship.
You consult yourself, you consult the
Advocate
AG
General has
others,
said.
and then convey the date to the
11 June.
Advocate
We'll-
General has
we'll-
said.
we'll convey,
11
madam.
June.
We'll
11
con-
June onwards. Yes.
11 June,
convey-
my lord. 11 June.
Mr.
The
AG,
exact-
11th June.
The exact date will convey in just 2 minutes, my lord.
11th June. 11th June.
11th. 12th June, my lord, 10th, 11th.
11th is a hearing day, Tuesday.
12th June. 12th June.
Anyway,
Interim stay passed by this court is made absolute till final hearing, final decision of the writ petition.
please.
My lord.
Oblige.
Obliged, ma'am.
For hearing, item 38 and 39.
May it please your lordship.
That clause 10,
Yes, my lord, that clause 10 of the tender conditions,
there are conflicting.
conflicting decisions of two honorable judges.
When the period of this settlement is
That is 30th of June. 30th of June.
30th of June. You are operating that,
No, the panchayat is operating that.
panchayat is operating.
I operated it for,
Anyway, by the 30th of June, they have to
Yes.
exercise the new
there will be new NIT.
NIT. Up to 30th, let the panchayat run the.
But then, my lord, if the validity of clause 10 is not decided, my lord, in that case, my lord, even if the new tender comes, there will be subsequent litigations again challenging the.
That purpose, yes, that's right.
इसमें the thing is like this. ये तो normally जो गाँव पंचायत और आंतरिक पंचायत लगती है। Because here the idea is that जितना high level court का ये तो फायदा है court के exactly इन कभी कभी हम तो अपनी मेरे सर
ऐसे पैराग्राफ से 10 लाख तो मिलेंगे
That is on the implementation. Also तो इसी का कंसेशन और वो भी 3 दिन का
Who is appearing for the state here? So what is your stand about this clause 10?
Supporting the clause 10. And
On what basis?
yes, so as per purpose 10, it's not violation of Article 14. Because, my lord, before participating, my lord, it's open for it's general condition for all the participants.
Here in many cases, suppose a person who has no intention, actually is not serious in settling the whatever the market or fishery in his favor or her favor.
और a busybody interloper महिला
Yeah,
busybody interloper
busybody or maybe is not much interested, but on seeing this, that the fishery is settled at a very less amount. And I can also manage it by paying 10,000, 20,000 more. Then at that time, he'll say, "Okay, sir, I'll furnish the documents, kindly give me the 3 days time." That's
We already offer, my lord, the highest bidder one, not for all. After opening the bid, my lord, initially it's a general condition for all, and to main utmost priority is the public interest, my lord, public finance, my lord. Because, my lord, these are the Gaon Panchayat and Nagaland Zilla Panchayat. Our main objective is to earn more revenue, my lord.
मेरे हिसाब से तो इसका आर्टिकल 14 वाला एंगल
Where accepted one.
in which that order read by the learned single judges set
Before
aside
that,
this.
can I have this argument? Load and technical matter, 2011-5, is completely clear.
Yeah. Yeah.
Mr. Datta, why are you relying on this? Which?
My lord, in this case, my lord, the apex court is saying, my lord, it is upon the authority to accept whether which in any bid document, my lord, one party is not submitting one document with the bid, my lord. It's up to the authority to accept that document later on.
But if there is a condition
Yes,
that
my lord.
no documents,
My
suppose here,
concern is-
but the law is also otherwise. That
Yes.
on the last date of submission, you have to submit all the documents. If no such document, it can't be accepted later on.
My lord.
This law is well
This
settled.
judgment is saying, my lord, that it's up to the authority to accept the explanation for not submitting that document.
Where is that? Where is that? But where is the question of explanation or non-explanation? Which para you are relying on?
In this case, my lord, that was not accepted by the explanation was not accepted by the authority. And apex court says that it's up to the authority.
Which
Fine.
para you are?
I agree with that.
ये जो clause 10, this is the better part in the hands of the which is to be exercised sparingly and on assessment of the expenditure. I think that it is quite vague, sir.
From paragraph 40. 45, maybe. Having considered the submissions made on behalf of the respective parties, we are inclined to accept the submissions made by the attorney general that the introduction of the corrigendum completely changed the provision in the bidder's expense from relating to 46. The above provision obliges a tenderer to produce along with the bid document a copy of the quality certificate which is valid and active on the date of submission of the bid, and it does not enable a bidder to withhold the copy of such quality certificate, where the quality certificate will be expiring shortly and is due for renewal. The bidder is also obliged to produce the renewed certificate at the time of signing of the contract. The appellant claims to have a valid and active certificate at the time of submission of the bid, but did not produce a copy of the same certificate along with the bid document. The submissions made on behalf of the appellant proceed on the basis that it was entitled almost as a matter of right not to submit the documents required to be submitted along with the bid documents on the position that even if such documents were valid and active, they could be submitted at the time of signing of memorandum of understanding. The appellant had a valid and active ISO so certification which is did not submit along with the bid document. May be different in advertisement, but whether such explanation was to be accepted or not lay within the discretionary power of the authority inviting the bids. The decision taken to reject the technical bid of the appellant cannot be said to be perverse or arbitrary. So I am submitting, my lord.
That is against you, mister.
That is not against my.
I mean to say that is against of the
That
state
is not
government.
restricted, my lord, but the
Stand of the state government.
I'm
Can't have the discretion
decision of the state
to
government.
accept the document after the time is
My
over.
lord, in that case, my lord, that was not a general condition that 3 days will be given. But apex court is saying that it's up to the authority to accept the explanation for not submitting the bill. In our case, we are giving to all it's a general condition, ma'am.
The question is whether any such discretion given to the authorities concerned to grant 3 days time to cure the deficiencies is in consonance with the constitutional provisions or not. This is what the question here. In that, what is your stand? Yes, it is in consonance with the norms or constitutional provisions. Not violating not violative of Article 14.
It's not my.
Or that doesn't give the arbitrary power to the authorities concerned.
My lord, for that, my lord, my submission will be, my lord, that it's not violation of Article 14, my lord, because, my lord, before participating, my lord,
Technically right, but then normally the reason is if division bench there is a difference in. You know, yeah, I don't know the reason. We can ask. Nisha, full bench. If there is a divergent view of two honorable single judges, the matter has to go to full bench or division bench can resolve.
Division.
Full bench is not required.
It was my lord in the first judgment, my lord. The process was not under challenge. In the second judgment, my lord, process was specifically challenged, my lord. And after considering everything, my lord, that was the order was passed. One.
The validity was upheld.
Yes. And
Whereas in the another judgment, the single judge, while dealing with the case, has made this remark that this is arbitrary.
yes. And thereafter, that second judgment was challenged by one petitioner. That was
That
also
has been-
rejected.
That has been dismissed.
Dismissed on technical ground.
Technical or whatever it may be, it is dismissed for all purposes.
Yes, yes. That was it. And in fact, my lord,
Oh, yes. Which is that single bench judgment wherein the validity has been upheld? Suraj Jamal.
Oh, what language? It cannot go. No way. Cannot go.
And the
Yeah, they also have to allow because of the
Clause can be in the contract, the tender.
the judgment whereby the learned single judge has held that this is arbitrary, which is that judgment is?
my lord, petition number
Name of the parties.
Abdul Samad.
Abdul Samad, yes.
Two judgments, my lord, Abdul Samad and Rafiqul Hussain. Rafiqul Islam.
But my lord, very interestingly, clause 10 is not challenged in this case. In the writ appeal, my lord.
In Abdul Samad.
My lord, present case.
No, in Abdul Samad, was it under challenge?
Abdul Samad, it was present, my lord, but in the present case, Amran Hussain last lord, writ appeal. my
See, Abdul Samad, the petitioner was not the highest bidder.
No.
He was the second highest bidder.
In that case, my lord, Abdul Samad case, he submitted one wrong document, my lord. That is why, my lord, clause 10 was not offered to him.
Mr. Chaudhary, you would be taking a stance that clause 10 is violative of Article 14. Is that your stand?
No.
Uh,
My lord, I'll put it this way, my lord. Ordinarily, yes, but having regard to the facts of the case, my lord, can it be looked into from this?
No, it is doubtful whether even ordinarily it can be said to be, of course,
No, my lord,
my lord.
I was looking it from a different perspective. Please give me 2 minutes time. My lord, normally eligibility of a tenderer is judged with reference to a date. Normally it is the last date of submission of bid. So by that date, you must have the eligibility. Now thereafter, if you make a non-eligible bid eligible, then my lord, Supreme Court has said this is violative of Article 14. Now, is it not a case where this last date has been extended by another 3 days? Now, how does it prejudice anybody, my lord?
No, last date is extended for 3 days
Yes,
in the present case.
yes. Because my lord, perhaps my lord, the concern of the authority is revenue. Now, having that in mind, if any bidder has not been able to produce some document which has relevant bearing in adjudicating his responsiveness, so 3 days time is given. Within these 3 days, you have to give.
To produce the documents, not acquire eligibility.
No, no.
These are two different
that
things.
document will establish the eligibility.
Mr. Chaudhary and Mr. Datta, whenever this matter is heard, whether today or, see, there are two aspects to this. Sir, I'm just pointing it out. First of all, it does not bear repetition, but Article 14 enshrines a philosophy, which is that every citizen will be treated equally in the eyes of law. Correct. That is a different matter. Here, as a matter of policy, these tendering authorities have notified that these are the terms, and in case of the highest bidder, the one who quotes the highest price, if there is some documents which are not readily available, then 3 days time, up to 3 days time will be given to the person to produce these documents. Now, this has to be looked into from 2 or 3 different perspectives. And therefore, this debate could be interesting as and when the matter is heard. First of all, if we straight away compare this clause with the international tender, then perhaps that will not be correct. One has to examine the settings in which these tenders are issued.
Clause has been kept to
These are all Gaon Panchayats, Anchalik Panchayats, local bidders who come in. They will have to get a certificate from a circle officer saying that there is no Baki Jai. They will have to get this certificate, that certificate. Sometimes these circle officers are not available for X, Y, Z, whatever reason.
Exactly.
So as a matter of policy, the panchayats appears to have taken a stand that somebody who quotes a high price and therefore the panchayat, the tendering body stands to gain. For them, there will be a concession up to 3 days to produce a document. So that concession perhaps cannot be read into presuming that this is an extension of eligibility. Rather, this is a concession given to furnish the required documents to establish the validity of the tender. All right, that may be a matter of perception, but that's all right. But two things. First of all, this is a declared policy. It's not all bidders know. Whoever quotes the highest. Now, if somebody quotes 10 lakhs and somebody quotes 5 lakhs, there is no question of equality. They are not equal. They may be bidders, but they are not equal. This is number one. If two persons quoting 10 lakhs, one is given 3 days and another is not, then maybe the argument of equality may come in. Otherwise, it is a matter of policy which is known to everyone. If you want to avail it, you quote a higher price. So I personally, speaking for myself, perhaps my lord will have a view in the matter, find it very difficult to agree that per se inserting the clause. If the clause would have said that at the discretion, any bidder will be given 3 days. Oh, then it is understandable. They're making it very clear. The one who quotes the highest price, he gets 3 days time. That we or may not like it. But it falls in the realm of a policy which is notified policy. Where is the question of violation of Article 14 here? Where is the question of violation of Article 14 here? We may agree with the decision, we may not agree. But to hold that it is violative of Article 14, that may be a little difficult because if you look at it from the touchstone of Article 14, the philosophy enshrined in this provision,
There is no
that is a different philosophy altogether. For example, if you are traveling in a bus, government bus, somebody who comes first and gets the first seat, can the last bencher say that it is violation of Article 14? Why am I not given the first seat also? See, Article 14 cannot be stretched to
End of the day, my lord, idea is to fetch more revenue. And in that process, if there is any shortcoming in the bid of the highest bidder, then he is given that time.
Right. So we would like to hear first those arguments which are contrary to this. Mr. Datta, are you
Nature-
saying that it is not valid? Are you saying clause 10 is violative of Article 14?
Yes,
You are saying that.
yes. It is valid of Article 14.
Now the question.
It is not a statute, it's a clause in the contract.
Clause,
And I-
clause 10. Clause 10.
Only question is this clause violative of Article 14?
Yes, Mr.
So-
Datta, you are ready,
Yes, my lord, I may begin.
having all these ammunitions with you. Article 14, because what the brother has suggested, it may be a somewhat difficult to hold that it is article violative of Article 14. For that, you have to take aid of, now it is open for this court to consider, for division bench to
Yes.
consider this question.
Yes.
We have gone through the judgments of single bench and everything. And in the last judgment of this Suraj Jamal, the division bench has kept it open, will consider it in if necessity arises in appropriate
But
case.
there is one technical problem. In this case, this clause is not under challenge. I think my learned friend will agree.
This clause is not under challenge.
In the writ petition, my lord, the writ petition was filed by my learned friend's client, my lord. The clause 10 was not challenge.
Then why should
But
we do it?
because of the operation of an interim order in the case, my lord, that came to be.
So you are basically aggrieved by the interim order.
No, I am.
Was challenged by writ petitioner, my lord.
I am
That was
aggrieved.
dismissed, my lord. In a different case.
I am aggrieved by the decision of the single judge in a sense, my lord, that the single judge, honorable single judge has decided the issue on two aspects. Regardless of the applicability of clause 10, my lord,
Yes.
the honorable single judge has decided the issue on the aspect that it's a case where my tender, my bid and the bid of the writ petitioner, they almost stand on the same footing because there are discrepancies in his tender as well, discrepancies or defects in his tender as well as in my tender. That is one of the aspects which has gone with the honorable single judge. And on that consideration, my lord, the honorable single judge has directed the tendering authority to redo the exercise.
So what is your, why you are challenging this?
I am challenging because I was selected as the successful bidder in the tender process. And while I was selected as the successful bidder, because of the honorable single judge's order in a separate writ petition, this clause 10 was not in operation.
Okay.
And it is in that context my bid was my bid was considered and his bid was not considered. He wanted to take benefit of clause 10, which was not available to him because of the order passed by the honorable
The
single judge.
learned single judge has not granted any relief to him, but has said that redo the exercise.
Yes, and at the same time interfering with my settlement. Now, my settlement was in pursuance of a minutes of decision taken.
Interim order is in your favor?
There is an order of status quo, my lord, and that's why the market is being operated by the.
Operated by, not by you and not by him.
No, yes.
So essentially, if, and again, the problem is that if you have not challenged the validity of this clause 10, then it would be very difficult for us to take up this matter without there being any challenge.
Now, in a sense, my lord, the clause, the validity of clause 10 is an issue which has direct bearing on the case. Because my learned
He is
friend,
seeking, but the learned single judge has not granted any relief to him also either.
no,
He has simply said, redo the exercise, that's all.
no, that will amount to granting him relief, because what has happened, if I can show your lordship the comparative chart that the Panchayat had drawn, his tender was treated as deficient. And since clause 10 was not in operation, so he was not given any opportunity to make good those deficiencies. And in that circumstance, my tender was accepted as the highest valid bid. So there is one aspect, my lord, as the query has fallen from his lordship, my
Despite
lord.
the fact that he is much higher than, his bid was much higher than you.
Yes, but in the set of the present the rules which are governing the present case, my lord, it is required to be the valid highest bid, not just highest bid. So the clause, I mean the Article 14, the application of Article 14.
So, Mr. Datta, Mr. Chaudhary and Mr. S. Datta, June is approaching very fast, so we don't think on the currency of the tender there is much scope. Academic issues, whenever it is raised, it will be looked into. Why should we go into that? It may have a bearing, but unless there is a specific challenge and the challenge is live, will it be proper for the division bench to give any opinion in that?
No.
It should be a live challenge. What is the purpose, even whether we hold this way, that way?
Now, if my lord, the honorable single judge had taken the view that clause 14 is violative, in that case, my lord, this judgment would not have followed.
You may have one pedestal, if you can show us. That is the finding that your bid is defective.
Yes.
That is wrong. If that finding is there,
Yes.
then there could be an angle here that a certiorari without a mandamus may not be permissible.
Yes.
So what the learned single judge has done is issued a writ of certiorari, but there is no mandamus in favor of. Normally, the principle of law is that a certiorari should be followed up by a mandamus.
Absolutely.
So yours is wrong, but his is not right. That
No,
kind of an order.
Answer is page 58 of the appeal memo.
What is
CS, page 58.
Page 58.
58, madam.
Yes.
Kindly see Mukhtar Hussain, that is we, and Amran Hussain Laskar A. Kindly see, my lord, I have quoted 1 crore 70, he has quoted 152. Kindly see how many documents he have not given. Caste certificate, no. Then revenue receipt, no. Jila Parishad thing, no. Then, my lord, Anchalik Panchayat, no. These are mine. And as far as appellant is concerned, my lord, caste certificate, no. Then revenue certificate, no. Again, revenue, no. Then, my lord, bank guarantee, no. Others, no. So,
That I can
Then
explain.
it's not even what remains.
No, that I can explain. That I can, because the conditions that have been taken into account, my lord.
No, Mr. Datta, you may explain. You have not challenged this. It is his writ petition. You have not questioned the procedure adopted by the body while evaluating the tenders. This procedure, the documents show that.
Because I was the beneficiary of this. I was the beneficiary, and kindly see my
Please
affidavit.
try to understand the query. What you were at that time is another thing. Today, your only relief could be to settle the order by which you were given the settlement.
Yes.
But unless you show that you had disagreed with these findings in the comparative statement, your settlement was also wrong. So in one view or other, the single judge's order kicks in.
No, my submission would be in the negative, my lord. The, huh?
18th of June.
18th of June will be. Missed on 18th of June.
18th of June. Published. My lord, the interim order may continue till then.
Interim order, if any, to continue till next week.
But there's an order of status.
Interim order, whatever it may.
Even if my
But
learned
it
friend's
will be
operation is
Interim
successful,
order, if any.
even if my learned friend's operation is successful, 30th June will set it.
But it will be a very, on a short campus, a very interesting debate,
Perhaps,
whether
my lord, that on an appropriate case, clause 10 aspect can be gone in because there is some confusion on that.
Confusion is there, yes.